today to reflect on one of the most pressing issues in our collection system. We are talking of the right to health in prisons. Right to health is a human rights issue. It is a human right, not a privilege. Health is a fundamental human right guaranteed under both national constitutions and also international human rights instruments. This right does not end at the prison gate, since we are talking of the prison today. So the right of health for prisoners does not end on the prison gate. In fact, it is international standards such as the UN Mandela rules and also African Commission guidelines on the conditions of arrest, police custody, and pretrial detention in Africa makes it clear. People deprived of liberty are entitled to same standards, the standard of health care as it is available in wider community. We always say that prisoners' health is public health. So the standard of health that is offered outside the prison should also be the same offered inside the prison. Yet across Africa, prisons are often overcrowded, underfunded, and ill-equipped to provide even the most basic health services. Currently, we have so many challenges. Prisoners in Africa, they share the same problems. We have these challenges that are facing our health facilities in our prisons. So the prison model law compels us to face realities we can no longer ignore. One of the problems that is faced by our prisons is overcrowding. Many prison facilities operate at more than double their intended capacity. This fuels the spread of communicable diseases such as tuberculosis, cholera, COVID-19, HIV, and other contagious diseases that comes because of congestion and the ventilation. We also have another problem that we face is mental health and neglect. If you visit in our prisons, maybe I will talk of Malawi Prison Service, you will find that there are inmates with trauma, depression, but they are not treated as the other people who are treated with the same types of conditions outside the prisons. It's because our facilities are under-resourced. Then we are also talking of women and special groups, the pregnant women, the mothers with children, elder prisoners, and prisoners with disabilities face unique health needs that are rarely addressed adequately inside the prisons. And also another problem that we face is the continuity of care. The after-prison services, healthcare services that are supposed to be provided to the former inmates, in most of the times they are not provided. So the prison model law as an opportunity for reform. We are here to discuss the opportunity for the reforms in our health services in our prisons. First of all, we are talking of integration of prison health into the national health systems. It is very important that our health systems, our collection services should be linked to the national health facilities. We know if some of you, like my colleague from Malawi, is an inspector of prison. He was trained as a prison officer. At the same time, he's also providing health services to prisoners. Sometimes the treatment that he can provide to prisoners, he will treat them as a prison officer. It also depends on who. He can treat them as a prison officer or he can treat them as a health personnel. So it is very important that whatever is happening in prison should be linked to the health services at the national health facilities. Mandatory medical screening at admission, during imprisonment, and upon release to detect and treat diseases early. This is also a contentious issue that we need to discuss, because most of the time we say that should it be mandatory for us to screen the prisoners, or should it be that a prisoner should come on his own? So these are some of the issues that we need to consider as we are sitting here. Gender-sensitive health services, we need to include prenatal, postnatal care for incarcerated women in our prisons. Training of prison staff and health rights and first aid, so that they can support rehabilitation rather than perpetuate harm in our prison. So the way forward for this is for the model law to be meaningful. We must move beyond paperwork. We have been meeting, discussing these issues, but it should be beyond the paperwork. We should take whatever we are doing here to our facilities. Budgetary commitment as well, from government to adequately fund prison health care. We have seen that most of the times the prison health care is neglected and is underfunded. Partnership between the ministries, Ministry of Health in this sense, the Homeland Security, civil society, and the international partners should strengthen the services in our correction services or prisons. We also need to intensify our decongestion strategies. That includes parole system, community service. We also need to intensify the camp courts in our prison, so that the prison should not have many people waiting for trials. Monitoring and accountability mechanisms, so that health facilities rights should not be violated in our prisons. Lastly, let me close by citing what Nelson Mandela said. Nelson Mandela said, a society is judged not by how it treats its most powerful people, but how it treats its most vulnerable groups. Prisoners may have lost their liberty, but they have not lost their humanity. By adopting and faithfully implementing the prison model law, we affirm the healthcare in our prisons is a right, not a privilege. And in doing so, we uphold our collective commitment to human dignity, justice, and rehabilitation. Thank you.
Need a microphone. Good morning, everyone. That's a very feeble good morning. Can we have another one, please? Good morning, everyone. My task is to give you an overview of the position paper on a model law on prison oversight. So I'm not going to go into all the details. It's a bit of a lengthy PowerPoint presentation. And I think if you're doing a PowerPoint presentation, one must disclose this in advance. You say, I'm going to do 10 slides or 15 slides. I'm going to do 39 slides. So let's see if I can do that in an acceptable time frame. So we've been working on this project for a year now. Progress has been made, and I think this consultation process will add value to it. But let me take you through what we've done now. There was a consultation process recently, so instead of trying to double edit, we're going to incorporate all those comments with this process, and then we can move forward. So, what is a position paper? It needs to define issues clearly. We need to establish our positions on particular issues, and in this case, prison oversight. So we need to provide evidence and arguments in favor of those positions. We must also outline policy and legal representation. So the position paper preempts the actual drafting process. It's an attempt to summarize and narrate the views of the stakeholders. Obviously, it must serve as an advocacy tool. It's something that we can take from here and engage other stakeholders with. Okay. Sorry, let me just get my mouse. All right. So, and the development of a position paper is also an exercise in building consensus. We come to this meeting or the other meetings with different views, and we need to find each other in a position where we say, okay, we broadly agree on this to move forward towards legislative drafting. So, it's that process of consensus building that is important. So, a bit of context about imprisonment in SADC. I'm assuming most of you have visited a prison at least once. Would that be fair? Is there anybody here who's never been inside a prison? Okay. It doesn't matter. We don't discriminate in that way. Everybody is included in the conversation. So, we've got about 400,000 prisoners in SADC. 156,000, and that's wrong, it's 160,000 are in South Africa and another 45,000 in the DRC. That means that half of SADC's prisoners are sitting in 2 countries. Roughly 3% are women, and that's a figure that's been creeping up ever so slightly, typically because women find themselves often on the wrong side of the drug trade. And we see that in South Africa, we see it in Mozambique. I'm not too sure about the situation in Angola. Imprisonment rate is 150 per 100,000 of the population, and the median The average is 150 per 100,000 and the median is 119,000. So the imprisonment rate across SADC is relatively high. We like to imprison people. That's the honesty. There's been limited investment in infrastructure. If we travel across the SADC countries, you will see prison buildings generally that were built by the colonial administration 50 years ago and older. Building prisons are extremely expensive and you have to continue maintaining them. You can't build a prison and then leave it. And that requires a budget allocation, and politicians are often very reluctant to invest in prison infrastructure. And the bottom line is that in many African countries, the infrastructure is so dilapidated that it's almost impossible, if not impossible, to meet the minimum standards of humane detention. So, prisons were built for men. That's it. They are 97% of the prison population, so we see prison infrastructure is very security focused. It's essentially there just to keep men and women separate, but doesn't accommodate women in any way whatsoever, in a particular way. There is very limited research on imprisonment in Africa, and I'm talking here about basic descriptive statistics that tell us how many people are there, who are they, how long are they staying there, how many people are admitted on a monthly or an annual basis, what's the sentence profile, how many times do people appear for bail applications. So it's that very basic criminal justice data that is missing from African research. So we have to start with the legal and policy justifications in our position paper. And the first one is the absolute prohibition of torture. And all SADC countries, except for 2, are states parties to the UN Convention Against Torture. And the convention and other international instruments provides the absolute prohibition of torture. There can never be any excuse for the use of torture. And so that is an important departing point. The African Charter on Human and People's Rights deals with the right to dignity, but also in General Comment 3 in paragraph 36, it places an additional, a heightened responsibility on the state when it deprives people of their liberty. There are also the African Commission guidelines on conditions of arrest, police custody, and pretrial detention, and the much older Robben Island guidelines on the prevention of torture. So, what is the need for our model law? For those who have been long around enough, will notice that post-1990, there was a wave of democratic reform that swept across the continent, and many countries adopted new constitutions, but that did not always translate into reform of principal legislation. So, for example, a new prison law. So, yes, there may be a prohibition of torture and a dignity requirement in the Constitution, but the prison law is still dated back to the previous century. That process is slowly changing, but it's not always on par. The legislation also comes from different traditions, different mandates and powers to judges, magistrates, members of parliament, civil society. So lots of variation in how the landscape looks with regards to prison, imprisonment, and oversight in the different SADC members and across the continent. Sometimes the oversight framework is very clear and specific. It says this particular structure has the following powers in respect of prison oversight, and it can do this and report that information to this body, whatever the case may be. But very often it's not. It's assumed that the parliamentary committee will have certain powers. It's not specific. And this obviously creates problems or uncertainties about how reporting is done and how oversight is exercised. There are also different understandings of what is prison oversight. And I'm sure if we go around the room and ask, what do you understand under prison oversight, we will get very different opinions. But we can broadly put it in two categories. The one is prison-based monitoring. So this is typically a person or group of persons visit a prison, they make certain observations, they look at certain records, they may even collect information from those records and analyze it. But the emphasis is essentially on the conditions of detention and the treatment of prisoners. And it's important that this is done because this is an important factual basis for oversight. But there's also another perspective on oversight, and that looks at systemic monitoring. And particularly, this is where parliaments come in, is that parliament determines the budget vote of the prison administration or the department under which the prison administration resorts, and then it's parliament's obligation to ask the department to come and account for how the budget vote was spent. And so parliaments are in a very powerful position where they can do a lot about prison oversight without ever setting foot inside a prison, by asking the questions about performance, about resource utilization, about dealing with complaints and requests, and various other issues that may be raised by other stakeholders. So those are the two broad issues that we can talk about in terms of prison oversight. A further motivation is there's no one model for prison oversight at present in SADC. We need to bring some standardization, some uniformity, some common understandings. Obviously, different countries can still apply those within what is appropriate for their local context, but we need to build some consensus. The importance of independent oversight was recently dealt with in a decision from the South African Constitutional Court, known as the Sonke decision. And the court said as follows: to effectively scrutinize correctional centers and remand detention facilities, an oversight body should maintain an arm's length relationship with the department, in this case the Department of Correctional Services. It should be sufficiently insulated from undue influence or capture. Capture is a very popular theme in South Africa. By the very departmental officials whose conduct it is charged with monitoring. In addition, it must gain the confidence and trust of inmates. Inmates' confidence in the work done by a correctional center oversight body will depend largely on the extent to which that body is perceived as being independent. So it must not only be independent in law and subordinate law, but it must also be perceived, it must be seen to be independent. So, if we then go on to the position on a need for model law, it needs to address gaps in existing legal frameworks. There needs to be a harmonization of fragmentation or fragmented and inconsistent oversight mechanisms. There must be clarity on the scope of oversight. There needs to be institutional independence, and there needs to be a common set of norms and principles that protect prisoners' rights while allowing national flexibility in implementation. Just on the terminology, Anneke, I believe we agreed to the term prisoner, but correctional center, if I have it correct. That's our definitions for the moment. We leave it to you to have your own interpretations and terminology. We're not going to allow ourselves to be distracted by that. So, in terms of our core principles and objectives, independence and oversight, the fundamental issue is that prisoners are almost entirely dependent on the prison administration for all their needs. If they have a problem, they have to go to an official. They're dependent for their health care, for their food, for contact with their families. Everything, it's that utter dependency that makes them so vulnerable to exploitation and so vulnerable to officials overstepping their own powers. And that is why we need to have oversight, to monitor that the state uses its powers in the way that it's intended, and that the state is accountable for how it uses its powers. So if we then look at the mandate and powers of oversight, and we're drawing here on a researcher who's looked at it a lot, called Ditch, it needs to be independent of the correctional agency. It can't be in that department. And that was the situation in South Africa, and we now have a constitutional court decision about it, and it's being fixed. It must be able to conduct regular, routine inspections. Prison oversight and prison monitoring is not about once-off visits. It's about a regular, sustained presence, recording information, and tracking that over time. Monitors must have a golden key. Effective monitoring requires that monitors have access to all people, places, and documents. Nothing must be hidden. They must be properly resourced to do their work, to conduct monitoring. They must have the power and the duty to report their findings and recommendations to fulfill the objective of transparency. It is important that we proverbially thin the walls between the prison and society. It's important that we, as free citizens, understand and know what is happening in prison and what are the expectations of performance. Or if prison is hidden from public view, then we know that violations will occur. And that requires that there needs to be proper reporting. There needs to be an holistic approach. It's not only about the treatment of people on a day-to-day basis, but it's also about the entire system performance. And it's also about investigating and looking at new developments and how we deal with them in the prison system. We must, or oversight must both fulfill the investigative and monitoring functions to provide accountability. It's this investigative function that is often very contentious, but when there are allegations that torture or other violations have taken place, these must be properly investigated. And those investigative agencies must have a proper mandate to investigate them. And it's not the prison administration that must investigate itself. It cannot. It's compromised from the word go. And then obviously the department, the administration, must cooperate fully. In respect of transparency, we can say that officials in the prison system must act visibly, predictably, and understandably. Those are fundamental requirements for transparency, because it's the standing orders and the legislation that must guide officials' conduct and decisions. In respect of accountability, we refer to horizontal accountability, those systems that the state introduces or develops to hold itself accountable in terms of its own procedures and practices. And then vertical accountability that refers to external oversight over a government, for example, the electorate or the media or an international treaty monitoring body. There must also be a protection of whistleblowers and complainants. These are dealt with in the UN Standard Minimum Rules for the Treatment of Prisoners, the 2015 rules. There must also, in terms of the rules, be internal and external inspection mechanisms, and there must be access to an external mechanism such as a national human rights institution, for example, a Human Rights Commission or an ombudsman. It's important that there's public participation and civil society involvement. The views of the public are important when we are drafting legislation. In the case of South Africa, this is a very well-established constitutional principle that the public must have a meaningful opportunity to engage with proposed legislation. We must also engage with civil society structures that are supporting prisoners. We must encourage a system where it's not civil society that is subsidizing imprisonment, as is the case in many African countries. We must also ensure that our model law aligns with international standards, such as the Convention Against Torture, the Convention on the Rights of the Child, the UN Standard Minimum Rules, the Bangkok Rules for the treatment of women in prison. And as far as possible, we must see how international standards are domesticated in operational orders. So, if we are saying that officials must act visibly, predictably, and understandably, it also means that investigations into misconduct should be prompt, impartial, and competent. That's wording you will find in the UN Convention Against Torture. There should be scope for external inputs. The findings must be made public. And there must be clear reports on preventive and corrective measures to be taken. It requires a mechanism to justify decisions, so our answerability requirement, and there must be enforcement for and consequences for misconduct and violations. It's really important that internal discipline in the prison system functions, and that if officials break the rules and the law, that they are held accountable. Otherwise, it communicates a message of impunity. So these must be imposed by independent mechanisms within the state architecture. If we look at horizontal accountability, there should be internal complaints mechanisms. That's a requirement in the UN Standard Minimum Rules. There should be designated oversight structures. It also provides for independent constitutional bodies, such as the Human Rights Commission. And there should be scope for civil litigation, suing the state for losses and damages. And so these structures must all be able to investigate effectively and make enforceable decisions to prevent impunity. If we then look at vertical accountability, these refer to external pressures on the state from the public. We see this in media investigations, civil society reports, international bodies such as the Committee Against Torture. I've already referred to those. The other emerging mechanism is the National Preventive Mechanism that's provided for under the optional protocol to the Convention Against Torture, OPCAT. And I think there are 5 SADC countries that have signed OPCAT: South Africa, Mozambique. No, it's only 2 then. Okay. Yeah. And OPCAT allows for international inspections by the Subcommittee for the Prevention of Torture. Mauritius have been visited, one of the first visits, I think the very first visit, and it did beg the question, why does the SPT choose tropical islands for first visits? But we'll leave that. So that mechanism allows for unannounced visits to any place of detention by an international body, which is just completely novel in terms of international law, that you allow a foreign body to come in and look at what's happening inside your prisons. So on whistleblowers, there should be anonymous and confidential complaints channels. There should be strong protection against reprisals for both complainants and whistleblowers. There should be a follow-up mechanism, and special attention should be given to marginalized groups such as LGBTIQ plus prisoners, youth, persons with disabilities, who are less likely to complain and more likely to face abuse and victimization. Early release. It's something that we have to deal with, and initially when we looked at this, we didn't think about it as an issue that oversight should deal with. Different countries have different early release mechanisms. In the case of South Africa, the situation I'm most familiar with, there's a very long-standing tradition of parole, a minimum non-parole period, and then the person is considered for parole, and then they can be released and serve the remainder of their sentence in the community under supervision. That's not always the case everywhere, so we do need to say something about it here. So what we recommend is that oversight mechanisms should not intervene in individual decisions, but rather focus on ensuring that clear and lawful procedures are followed. And I think that is very possible. So that would look at reviewing the legal and administrative frameworks, assessing the structure and representativity of early release bodies, ensuring performance indicators, and then look at rates of compliance, the complaint systems, and community support. So those are systemic mechanisms that an oversight structure can look at. So there are broader issues around research, legal monitoring, and reporting to the legislature to promote good governance and uphold prisoners' rights within the early release system. Then mandatory reporting. We include mandatory reporting into the model law to ensure that there is at least a minimum standard of information that must be made public across the entire prison system. And typically this should be reported to Parliament, but we're not restricting it as long as it's put in the annual report, preferably more frequently than the annual report. And these are what we call critical incidents affecting prisoner welfare, institutional integrity, and the rule of law. So the prison administration supported by oversight structures should be encouraged for publicly reporting general quantitative data, not data, on the prison system. So we're talking about population data, not only how many people, but what's the incarceration rate, what's occupancy level, in other words, how many people in a prison, compared to for how many people it was built for, staffing ratios. Then if there is rehabilitation data, so at least participation in educational or work programs, and also parole rates. So do people all serve until expiry of sentence, or is there a significant proportion that are released? Health indicators, and that's our focus for this consultation. We're looking at disease prevalence. There are certain illnesses that are very prevalent in prison settings, and it's important that we report that. There are also certain illnesses that we know are indicative of poor conditions of detention. such as scabies. Mental health services, I think if any of us have walked around in prisons and spoken to prisoners, mental health issues are extremely common in the prison population. It's probably the understudied topic. And then also nutrition. What is the quality of the diet? How many meals a day? Is the diet varied? And those are important things, because if we focus on those type of things, preventative interventions, then we prevent problems later on with serious health concerns. Oversight data, how many inspections, how many complaints, how many investigations, how quickly were those investigations completed, and so forth. And then the financial metrics, cost per prisoner, budget utilization, investment in rehabilitation versus security. Those are important issues for prison oversight. Now, if we then turn to the role of oversight structures and investigating crimes implicating officials. The first is that there should be a central register of complaints, and there must be unique case numbers so that we can actually track complaints and how they are resolved or not. There must be a confidential, accessible complaints channel for prisoners, and there may be some variations here. We typically see, and the UN Sandeman rules require that there must be a daily opportunity. So you have a typical register that is used in the cells or the sections. But very often, prisoners don't want to complain on that platform. They say, no, I'll speak to the social worker, or I'll speak to the nurse, or I want to speak to the head of center. So we must ensure that we have a consistent mechanism there. There must be prompt investigations, especially with serious matters. There must be direct injury reporting by medical staff to the Independent Investigations Directorate or equivalent body. Now, we use this term Independent Investigations Directorate as there is not something like this. We're not saying there must be something like this, but we're saying is that somebody must fulfill these functions. So for us, it's just a term in the meantime until we finalize the draft law. There must be proper evidence collection, including interviews and forensic examinations. There must be an analysis of legal and systemic factors. There must be recommendations for prosecutions or disciplinary actions, and that the victim must be protected, and if need be, relocated and support services rendered. And then the Investigations Directorate must submit annual reports to Parliament detailing the number of complaints, how far investigations have gone, what were the outcomes, the reforms, and there must be mandatory publication of this information. If you want to see an example, the South African Independent Police Investigating Directorate, in their annual reports, they actually publish by name, station, what the crime was, what the result of the investigation. That's the type of standard that one must be aiming for. So legal reform should ensure that there is mandatory cooperation with the Investigations Directorate. There must be the criminalization of torture and investigation obstruction in domestic law. Article 4 of UN CAT requires criminalization. It's not always seen in domestic law, and there must be protection of whistleblowers. So these measures aim to ensure credible, victim-centered investigations and reduce impunity in prison systems. If we then turn to vulnerable groups, I'm at slide 21 of 39, in case you're keeping track. We're getting there. There are a range of vulnerable groups, and their vulnerability is only accentuated in a prison system. So we must be on the lookout for particular factors. But yeah, they're listed there, but definitely persons with mental illness, foreign nationals, and stateless persons. If we then turn to the position on the conditional release of unconvicted inmates, as the stats showed earlier, we're looking at roughly 35% of prisoners awaiting trial. So they are presumed innocent, yet they find themselves in the situation where they are in custody, often for very, very long periods of time. And this can run into years that people are awaiting trial. We did some research on the socioeconomic impact of pretrial detention, and I think for us an important finding was that even though it's the majority of pretrial prisoners are men, the burden of dealing with that pretrial detention falls on women disproportionately, because it's women who must now step into that role of an income earner in a household that is now in custody. They must not only generate additional income, but they must also bring food, money, etc. to that detainee. So we need to have measures in place to ensure that pretrial detention is used truly as a measure of last resort. So oversight bodies should look at this in a systemic way, particularly at looking at the links between access to courts, access to legal aid, and family contact. Then there is the reporting to international and regional treaty monitoring bodies. The UN Committee Against Torture requires every 4 years a periodic report. The Committee on the Rights of the Child requires reports on children in detention. The Human Rights Committee that oversees the ICCPR also requires regular reports. State parties to OPCAT must also submit regular reports. The African Commission on Human and People's Rights requires reports every 2 years. So if we're looking at this reporting requirements, it follows that there must be a system in place across the state to facilitate this reporting, and that it's not necessary for us to every time from scratch go and collect data. There should be a system in place to collect this data and direct it in the correct channels. So if we're looking at the functions and structure of the oversight body, with reference to composition and appointment, important would be independence and autonomy. There needs to be representation from a wide range of fields. It must be merit-based selections, and there must be tenure and security of office. There must be funding and operational autonomy, and we can also make a distinction between different types and perhaps more appropriately different roles in oversight mechanisms dealing with preventive, investigative, and systemic oversight. We can also anticipate some challenges. There may be resistance from correctional authorities. Simply put, in general, prison administrations don't like it when outside people are walking around in their facilities asking questions and looking at how they're doing their work. So one can anticipate that. There could also be political and bureaucratic hurdles with reference to what is in the constitution of the country, what powers are given to members of parliament. Sometimes they're very specific and sometimes not. And how is the budget determined? there are obviously resource and capacity constraints. And one must look at what are the cost drivers and the priorities. I'm not going to go through all the detail, but I want to emphasize that quantitative data is really important. In other words, statistics. It's important that we have that information to shape policy debates, and that we don't base policy debates on anecdote and personal experience. There are historically many promising practices dating back to the 18th century. I'm not going to go through that. There are different modalities and best practices within SADC that we need to acknowledge. So those in green are the countries that have ratified UNCAT. And the prohibition, we must always read together, the prohibition of torture, we must also always read together with Article 16, paragraph 1. And that the prohibition also extends, or the duty to prevent also extends to those actions that do not amount to torture. And that there must be a systemic, a regular systemic review of the interrogation rules, instruction methods, and practices, as well as the arrangements for the custody and treatment of persons deprived of their liberty. So it's not a once-off, we must continue. The optional protocol, we now have several countries, those in green, that have ratified, and that's a very positive development. They're at various stages of implementation. The countries in green have visiting justices, or at least provides for in law. Then we have national human rights institutions visiting or can visit facilities. Those on the left, the countries in green. Countries in green on the right have official visitors visiting places of detention. The countries in green, and this is perhaps more a civil law country, so that's why we see Mozambique, Angola, DRC, and Madagascar, who have prosecutors visiting places of detention. I think it's a very interesting mechanism. And then independent oversight bodies, the countries in green have them designated in law and they are functioning. The countries in red don't. The countries in orange have them in law, but they're not implemented. Very briefly on information flow. On the left-hand side, one is looking at an information flow from an NHRI or independent body to Parliament. And on the right-hand side, we're looking at a visitor's book comments by visiting justice or an official visitor that goes to the officer in charge, the Commissioner of Prisons, the Minister, and ultimately to Parliament. It's important that these channels end up in Parliament because that is where the executive must account. Prison visitors, committees or boards, they are essentially lay visitors. They are members of the public who come and visit. It's an important mechanism because it brings that transparency to the system. I'm going to skip through this. In terms of reporting systems, it's important that there are mandatory reporting systems by the correctional authorities that would facilitate desk-bound oversight and reduce costs. So if our systems are in place, we've made an important step in the right direction. Shared databases or a platform for exchange that allows submission and tracking of thematic and individual complaints. Information needs to be shared on departmental websites. It's really helpful if one can go to the department's website, and you see here all their annual reports, and there's some additional reports and some research reports. That really helps us to understand what's happening, but it also signifies to us that this department is willing to open up. They don't want to be secretive. They're not represented here, but the Kenyan prison service must really take a feather in their cap for that. They really made a policy decision more than 10 years ago to be open and transparent, and they truly are. The legislative pathway is set out there. We are now at the fourth bullet, stakeholder consultations, slightly into the drafting process. And then there needs to be capacity building and training needs to be identified, and that will develop over time. Continued stakeholder engagement, there's a long list of people that needs to be consulted. The monitoring and evaluation framework needs to be developed. This is something that one can build into the legislation, that you say that there needs to be regular reviews of this mechanism every 5 years or whatever the time frame is. So yeah, it's a position paper. It aims to build consensus, and we need to delineate that scope. I hope we've gone a long way in doing that. And that's it. Thank you very much. I don't know, what are we doing now? Take questions or roll on or... Okay. There's time for questions. Okay, no questions.
Okay. Yes, 30 slides are detailed, so there shouldn't be questions. We can always send this to you. Okay, do you have a question?
I just want to know, in the process of developing the position paper, was there any kind of process where you did almost a scorecard of the position now across SADC?
Yes, so we have a table with all the laws in each of the SADC countries and how all of that, like which have what. It's not, no, it's not the long annex at the last one. It was a separate document that was developed. So there's a detailed document just setting out all the laws in each of the countries. When it gets to the model law itself, we then used the positive legislative provisions in each of those laws to actually copy and paste it into the model law, and we footnoted that so one can see where the sections were taken from. Any other questions? Yes. Oh, you can use that. Is it working? Yes.
Yes, it is. I would like to know if currently, because our aim is to have an independent body which will gather information from the inmates who will trust that body, is there currently any countries having that actual independent body? Because in Mauritius we don't have, even our visiting committees are hired by the state, so not really independent per se.
Okay. I mean, Victor can come in on the Malawi situation, because in the case of Malawi, it's the only country that I know of where this was created in the Constitution. In the case of South Africa, there is the Judicial Inspectorate for Correctional Services that's headed up by a judge of the High Court. And it employs a team of inspectors and then independent prison visitors or independent correctional center visitors. And they are people that are employed under the inspectorate. Now, that sounds very good. The issue was that the inspectorate's budget came from the Department of Correctional Services. So yes, in law they said we are independent, but in practice not. So this was taken to the Constitutional Court in the Sonke decision, and the court said, no, That is not independent. You need to separate from the department. And so now we have that. I think they are still tweaking things and getting it ready. But as far as I understand it, that is as independent as it's going to get. It's outside of the correctional services budget. It's headed by a judge. There are obviously practical issues. But maybe Victor wants to come in on the Malawi example.
Yes, in Malawi, we have that one in our constitution, the Inspectorate of the Prisons. It actually started in 1994 after having a new constitution. But the unfortunate part is that we don't have a secretariat up to now. But we go and visit all prisons. The inspectorate is also headed by the High Court judge, and he has got members from some departments, like the Chief Commissioner of the Commissioner General of Prisons, which we also think is not proper, and then some government officials. I'm representing the civil society in that committee. But I think the only problem is that we don't have the secretariat. But we have been producing reports to the parliament. And sometimes they were being tabled, sometimes they were not being tabled. But we visit almost each and every year. So this time around, we are having a new Prison Act. And we are having some roles on top of the roles that we had already. So we are in the process of having a fully fledged prison inspectorate. But aside that, we also have the judicial, we call it justice visit. They can visit the prisons and issue reports. And again, they've been visiting, some of them have been visiting upon the invitation, but it's their duty to do that. But the problem is, after issuing the reports, sometimes there's no feedback. Thank you.
Thank you very much.
Thank you very much. My name is Yvonne from Namibia. Just a quick question on the assessment of jurisprudence across the region. I see that you have cited the South African case, but I was wondering whether you've looked at other jurisdictions in terms of their case law, and also what are the kinds of norms and standards one can extrapolate from the jurisprudence in the region.
I'm not a lawyer, so I'll give it to the lawyer.
Yes, in terms of developing the model law itself, we looked at not just SADC jurisdictions, but all countries within Africa, and some other countries in Latin America, Europe, and Asia. So it was quite broad in terms of looking at those things. Very little jurisprudence on the principle of oversight. So there's quite a bit of jurisprudence on, for example, torture in prisons, conditions in detention, those sort of things, but not, the Sonke one is almost the only one that actually deals with oversight itself. I think partly because oversight is not that well developed, and that's the whole point of the model law to start off with. Humphrey.
Oh, thanks, Annika, and thanks for the presentation. I just like the concept of, a very good quality standards in and outside the prisons. And I was just kind of wondering, really, what is the quality of life of prisoners after incarceration? Have we bothered to have a dipstick of understanding to prisoners last? Does imprisonment really work as a system, or people just disappear, pass away, and we don't know what happens to them after that?
We can have a whole meeting on that question.
Yeah, I mean, I think the question, and I don't have a clear answer for you, but at least two remarks, is that we really need to ask the question, how did this person end up in prison? What preceded this? Did they just wake up one day and decide to commit an evil deed? Or were they victimized when they were still toddlers? And over time were marginalized and victimized, and there's so many things that that play into that ultimate imprisonment. That's the one angle for me. The other is so now we imprison somebody, we punish them for doing something wrong. We don't punish the system for failing them getting there. And now we expect them to be law-abiding citizens. But if we look at the inside of our prisons and how people are treated, do we really have a realistic expectation that this person is going to now be a normal, balanced, functioning individual participating in the economy and I think our expectation is misplaced.
So conditions in detention are terrible. And any other questions? Moses, yes.
Thank you very much for your presentation. It sometimes happens in many countries that prisoners are given the benefit of parole, or sometimes they are released early, unexpectedly. You're moving up and down in the village and you suddenly come face to face with a prisoner who had been sentenced for a very long time because of something and suddenly is in the community. And I'm just wondering, how prepared are families and communities for this kind of, eventuality? And do you think it is something that a model law should be vocal about? What support do minders of prisoners actually require? And again, do you think that the SADC model law that we envisage should be vocal about? Thank you.
Thank you. The model law is about prison oversight. And I think our focus must remain on the role of an oversight agency. And it must look at how decisions are made. So if it is decisions about early release or parole or whatever, remissions, yes, there's a role for prison oversight agencies to ensure that that process is transparent and that the decision makers are accountable. I don't think it is for a prison oversight agency now to make its hands dirty with operational decision making and individual cases. No. I think the duty is to focus on transparency, accountability, and how decisions are made. Thanks.
Okay. We are going to go into the nitty-gritty of the actual model law and go by it line by line, which is going to require even more attention and concentration than listening to Lucas speak on the 39 slides. So I would suggest we take a half an hour break now for tea and coffee. You might need more coffee than tea, depending on what perks you up. Then we're going to come back here and then I'll explain to you the whole outline of the model law, what it's sort of where we see different things fit, and then we'll focus specifically for the next 2 days on the issues relating to health in prisons, as opposed to dealing with every single issue linked to oversight. So let's have a quick break for half an hour and then we'll continue. Hi everyone. Can we start? So, I'm going to take you through the model law quickly, and then we can go into a bit more detail. Has everyone received a copy of the model law? Did you get it by email? Or you have a copy of the link? If you have a copy of the link to the model law, then you can make proposed changes, track changes to the model law. That will help us so that we can ensure everyone's views is properly included. We had a similar process 2 weeks ago where members of the technical working group also gave quite a bit of input into the model law. It has changed quite a bit, but I'm taking you through the original version just because some members of the technical working group are still sending through their submissions and those sort of things. So once we get everyone's submissions, including the submissions from today's meeting, we will then revise the model law and send that to everyone to just give additional input. The actual final version of the model law should be, well, not final, the public version of the model law will be done by the end of October. That's the version that will then be published for public comments and submissions. So there is a whole nother process to the model law after this. These are initial consultations with people like yourselves who are experts, so that we ensure that most of the technical aspects are covered in the model law, and then there will be a public version that will go out for submissions, and you're welcome to, at that point, also make submissions. I want to take you just quickly through the scope of the model law. So, just to note that the model law does not deal with conditions in detention or prisoner rights or any of those sort of things. The reason why it doesn't do so is because all of that already exists. You have the Nelson Mandela rules, the Robben Island guidelines, the Bangkok rules. There's a ton of, in fact, it's all listed there in the introduction to the model law, but there's literally a ton of international and regional minimum standards for prisons. This process does not intend at all to replicate that. So this model law is not about minimum standards, because that exists already. What this model law is about is oversight mechanisms for prisons. And it's really about us creating a framework that people can apply in their laws. So just to explain, you saw when Lucas showed the little maps of the different countries. All our countries have national human rights institutions such as the Human Rights Commission or Ombud, who is legally mandated to go visit prisons. So that's one independent oversight body, right? Then in all our countries, either judges and or prosecutors are also legally mandated to visit prisons. That's a different oversight body. Then in many of our countries, there are visitor committees. That's another version. And then in a select few countries, there are independent oversight bodies. Now, the model law cannot ask a SADC country to immediately have an independent oversight body. I mean, people are here, it's costly. For no other reason. What we really want is we want to improve each of the different oversight mechanisms. So if the Human Rights Commission goes to a prison, that's great, but sometimes the Human Rights Commissions might not have the best powers in their own operating laws to make recommendations or to visit every part of the prison or those sort of things. The same with judges. Judges can go visit prisons, but often there is no process in place legally in their countries for what happens with the reports after they've visited prisons and how their recommendations are implemented. So the aim of the model law is it's basically in different sections. And it's taking what already exists in all our countries, and then it's trying to suggest what the best practice might be for improving those operating laws under which our oversight already happens. In some countries, there aren't necessarily all of those oversight bodies, so then a country might decide to adopt an independent oversight body or those sort of things. So it's more about, the law is not going to go to a country and they're going to create, they're unlikely to create a whole new law in your country. What's going to happen is that you have the model law, and then if your legislature says, okay, let's improve our human rights institutions oversight, and let's think about a designated oversight body a few years from now. Then at the very least, they can take the section in the model law on national human rights institutions, they can go to the National Human Rights Commission Act, and they can improve sections in the Act based on the model law. So the same would be, so they can apply various sections, but ideally, like we said before, ideally what you eventually want to get to is that all the different oversight mechanisms work together. And you can't have one and not the other, really. And ideally, eventually, you want a designated independent oversight body. But there's a lot of things that might depend on. If you have a tiny prison population, it might not make sense to have a designated oversight body. You could combine the oversight body with a police independent oversight body. There's many things one can do. So it's not to be prescriptive, but to show really what the best practices are. And our job here is really to, before the model law goes public for submissions, for all of us to really think about what else can one add to it. Now, our reflex will be to start listing all the health problems. This is not the purpose of the meeting, because we know there are health problems, that's why you're here. Our purpose is to figure out how do one improve oversight so that one can ensure that health problems don't remain the same in prisons the whole time, but there's people who actually check on the prisons, make recommendations for improvement in healthcare, and that those recommendations are actually followed through. So it's how do you create a system that will ensure that the health problems actually change and improve because there's oversight. So with that being said, I'm just going to take you through the framework by going to the index. I never thought a table of contents would be this useful, but it does summarize the issues. So the first part of the model law deals with how one would domesticate it in your own country, sort of the ambit of it, and some of the definitions and principles around it. Now, there might be principles that you want to add, there might be definitions that you want to amend, especially from a health perspective. There might be additional definitions you think need to be in there. Then there's a section on complaints management. Now, this is slightly different from an oversight body, but it's as important because there should be a system in place through which prisoners can lodge complaints or file requests both internally and externally. And that process needs to be properly provided for so that they know what that process is and it's applied equally to everyone. So you have that sort of way in which it is also a system of oversight if you think about it, because if many prisoners lodge complaints about not getting proper food, then that should already be flagged as clearly there's an issue within this prison. If those complaints are documented, then whoever does oversight can also look at the registry of complaints and through that registry identify what some of the problems are. Then what you have is you have internal oversight by correctional services. So this would be where they actually do inspections of prisons. And they make sure that those inspections comply with certain regulations and are compliant with the law of the country itself. I think for the purpose of our discussion today, we might just review that internal inspections section just for you to see whether there are aspects around health that ought to be included in it. Then there are what is called official visitors. These are all the people who are allowed access to prisons. Now, there was a huge debate about this at the technical working group meeting 2 weeks ago because people felt that there ought to be it ought to be differentiated between people who can visit a prison at any time without giving notification that they will visit, and people who can visit the prison, but at the very least they ought to say that they're coming. And that is just based on different official visitors perhaps coming with a different mandate. And you can't also have everyone rock up at the prison all the time, because that might compromise other procedures and those sort of things. So were discussions around official visitors, and specifically within those discussions, the principle was that every country will eventually determine who the official visitors are that can go to a prison, and at the moment that is already set out in your Prisons Act or your Correctional Services Act. In some countries like Eswatini, this is a long list of people who can come. Although in practice none of them get allowed access, but theoretically there's a long list of people who can visit the prisons in Eswatini. In other countries, the list of official visitors can be 3 or 4 people. So normally members of parliament, judges, national human rights institutions, but there might be other people there. And again, here you want to look at whether it's necessary to include, for example, district health officers or people who are operating within health but independent from correctional services itself. And that might become quite handy, for example, if there's public health concerns or suddenly you have a COVID pandemic and no one knows what's happening in the prison or whatever else. Then judges we're not going to go into today because we'll speak about that later in the week. We have judges coming on Thursday. The same with national human rights institutions, they will come on Thursday, so we won't deal with that. Then there is a whole section dealing specifically with designated independent correctional center oversight bodies. Again, this is very much just dealing with the oversight bodies themselves, and we wouldn't need that for the purpose of this discussion. There are, in all our countries, we have commissions of inquiry laws. Now, this very seldom gets, people might think, what has a commission of inquiry got to do with prisons? But it can be used as oversight if there's a systemic problem that raises enough concern for the government to decide to actually have a commission of inquiries just on that issue. In South Africa, we had it started with a J, Jolly Commission, which initially started off being just about corruption in prison and then went further into lots of other issues. But it was about identifying a specific problem. Now, you might think, okay, it could actually be quite handy if we all know there's a TB outbreak all over, or say, for example, there's never food in prisons, right? And there's constant problems with lack of food in prisons, but everyone blames everyone else and no one actually figures out what the problem is. A commission of inquiry might be actually useful to identify the exact points. And it might then require like a more holistic investigation than what you ordinarily would have if people just go and visit a prison. So that's one issue we're just flagging. Now, the real nitty-gritty, juicy part for today is health professionals. And see, we only have 2 sections there, so you might at the end of today suggest that there should be 10 more sections for all we know. If you get really super excited and want the right to go visit a prison at any point as a healthcare worker. And you might want to increase or broaden the list of who are defined as health professionals and all those sort of things. And really the issue there is and I'm not sure if we've actually properly dealt with it within the section, But to think about it this way, you get, and this is why it's good, because you have people here who are health professionals within prisons, and we have people who are health professionals within departments of health. Where are the gaps? You know, like, who's overseeing the health professionals who are in prison? What about, for example, if a health professional works in a prison, sees a prison warder abusing a prisoner, or gets a prisoner to come to a prisoner comes to them and clearly has been tortured or something? What are their ethical obligations? If they feel they can't do that sort of reporting because of the position they're in, how do we make sure that other health professionals external to the department actually, or to the correctional center, also frequently visits the correctional center itself? And then there are issues about how do we even monitor if there's at all any sort of referral mechanisms in place once prisoners are about to leave prison, or just when they get into prison, and in terms of continuity of care and those sort of things. So lots of issues there we need to flag out, and we'll go through it. Then there's a section on protection of vulnerable groups. The section is not exhaustive. It's debatable how one would, whether you need independent sections or whether you need one big section saying all people are vulnerable, or what. But within this group, there are specific subsets of people who I think you as a group might have a particular interest in. I mean, you mentioned, for example, working in neonatal care and looking at babies born to mothers in prison. Issues around people living with HIV. Now, the reason why this section is lived separate is because of our history around HIV in our region, where obviously we're the region worst affected in the world with HIV. And also because there are minimum standards within SADC on the treatment on HIV relating to prisons. But you might decide that it's not an issue anymore. I mean, personally, I don't think that the stigma is necessarily there in the same way that it used to be. So there might be bigger issues. Why don't we have here persons living with tuberculosis? Do we broaden it and say persons with communicable diseases, or does that then take away from the specific issues one need to monitor if you are oversight body? Listen, we're not talking here about the actual care. We're talking about, as an oversight body, what do you need to go ask? What do you need to make sure when you get there? And so, yeah, so it sort of deals with some of those. It would impact, for example, what you would ask different types of prisoners also. Survivors of sexual assault, there's many healthcare issues there that we all know doesn't get properly dealt with within the prison system. What should an oversight body do? And this section should really be dealt with separately. So the part about intellectual and psychosocial disability should go with persons with disabilities. And then there would be a separate section on people with mental illness. I don't know if mental illness is the correct terminology. But then one needs to think about, are there stuff there that isn't being considered? I mean, there's a big debate about should this whole oversight law perhaps be extended to also apply to mental health institutions where people are incarcerated, because they're very much like prisons, and people are held there against their will. But that's a whole different question, I suppose. But I think the one group that can legitimately flag that would be your group if you wanted to. Old and infirm prisoners. Are there specific issues there? Like you might want to consider there, for example, whether there are sufficient processes in place to identify prisoners who ought to be released or ought to receive palliative care or whatever else. You know, like there might be those sort of concerns that you might have. To be honest, I don't think prisons at all care for old persons, perhaps occasionally giving them nutritional supplements, but very little else is being done. There might be other issues coming in there around old age that no one's ever considered, like dementia. And whether, you know, like, and how do you, and if, like in South Africa, they keep on sentencing people to life in prison, you're going to end up sitting with a very old prison population at some point who need specific care. They might need nappies, they might need other stuff that no one's ever bothered to ask. I'm just putting it out there. So this is your day to raise all the issues that no one's ever bothered to ask. And now the other juicy bit, training and mandatory reporting. Lucas and I were debating this, and we thought you should have mandatory reporting on everything, because then the more stats we can get, the better for oversight. You know, like, so everything there should be mandatory reporting on. But as there are correctional services people in the room who might think that that is a bit difficult, and it might make your life harder, I don't know. So you might want to streamline mandatory reporting or have easier ways in which one do mandatory reporting, but definitely included within mandatory reporting would be duties around mandatory reporting for health workers. And duties to report specific things, like if people have been raped or tortured or died in custody and those sort of things. There's very little in the model law on oversight relating to inquests. We know that the laws require that if someone dies in prison, there ought to be a proper process to investigate why they died, how the reasons and those sort of things. And an oversight body should be able to go to a prison and see if those processes are being followed. But I think in practice they're not being followed, and there might be additional things you might think could be put in place to improve that. And then the last section of the model law really deals with parliamentary oversight. And what do we want parliaments to do? And who in parliament? So for example, most of our countries don't have a specific portfolio committee dealing with correctional services. For the purpose of this meeting, we do have portfolio committees dealing with health. What should that portfolio committee on health do when it comes to health in prisons? Should they visit prisons? What sort of information do they need to conduct proper oversight of prisons? So all those sort of questions. I think when we go through the model law, have those questions in your head, and then think about how sections can be improved. And you don't have to feel all prim and proper here. You can destroy sections, that's fine. You can say it's a crappy section, that's also fine. We are not invested in the sections. The more debate there is, the better. The main thing is, don't go back to what the conditions should be, because we're not dealing with conditions, we're dealing with oversight. Any questions about the process going forward? We're going to go section by section, skip some of the sections, but then, and then as we read a section, we'll then have a quick debate. So if you have the model law open in front of you, please, in track changes, you can put your comments there as well, but otherwise raise your hand and make your comments, then we'll take note of that and include that in the amendments of the model law. Yes? Are we ready? Yay. Are we all energized? No. But we can get there, people. Okay. Quick point. Right in the beginning, when we have the preamble to the model law, and we recognize that some people might be a bit more vulnerable because of their status, including their health status, we acknowledge that there are the UN standard minimum rules for the treatment of prisoners, the Convention Against Torture, and lots of other instruments that require oversight. And then there's some requirements around oversight. Quick question. As health workers, are there international standards separate from prisons that you think ought to be referred to in the model law that guide how health workers operate? I'm just asking because I'm not a health worker, so I don't know. You can research it and come back tomorrow if there are. But I'm just checking because obviously, as human rights people, we might be biased towards certain pieces of international law and cite them, especially as they relate to prisons, but there might actually be other ones that create certain requirements around mandatory reporting for health workers, or around ethical duties of health workers, or around the need for governments to not have reprisals against health workers who complain about certain things. Any of those things, think about it. If there are those sort of standards that ought to be included in the model law, just let us know. Lucas, are you thinking about it already? Yeah.
I don't see the Istanbul Protocol in our...
Yes, we
That
didn't put it.
concerns the investigation of torture and assigns very specific duties to health workers.
It's actually later on, but it's not in the intro, so please add it there, Lucas, while you're there. Anyone else? Yes.
There is the WHO normative guidelines for key populations, and there's prisoners and people in closed settings.
That's exactly what I wanted. Thank you so much. So did you write that down, Lucas? WHO normative guidelines. Thank you. Anyone else? No. Okay. But if there are more, let us know. Then, under definitions, yes.
I thought you were just dealing with the conventions that were not incorporated. Firstly, I need to generally understand where we're coming from here. This is a mere outline, right, that you intend to incorporate into a model law. Yeah, I just need to understand, because it looks, your title is that an outline on the model law on prison oversight. So it's not the actual model law that is still to be drafted.
It sort of is already. It's just that there hasn't been, I mean, not in terms of how a model law might look, but it's taken all the references from different laws and incorporated into one document. And part of the consultations is to determine whether some sections are needed, some are not needed, all those sort of things. But I would think that many of the sections would go directly into the model law.
Okay. Yeah, because I know SADC is like developing jurisprudence over model laws and their format, their presentation, their citation, their explanatory notes and so forth are pretty much standard now, right? And we've had a number of model laws coming on to the compendium of SADC model laws. So it makes it much, much easier for any user to pick it up, be it a legislative drafter or a parliamentarian, or indeed portfolio ministries, to understand what their obligations are in the domestication process of the model law. So looking at the outline, to me, I'm a little bit confused, and I would like you to clarify the format that has been used in order for us to move quickly through it. You are doing the memorandum, and if I look at the preamble, when I look at the preamble and I look at the next sections, which is the general provisions, and then the definitions and so forth, and the application and scope, I find that quite a lot of that content is supposed to be in the preliminary part of the model law, which is the explanatory notes and explanatory content so that it's not confused with the actual incorporation of principles, obligations, functions, and roles in the substantive part of the model law. Because when, as a drafter, we look at a model law as a very, very important piece of tool that will help us draft national laws very clearly, incorporating required standards. And if those are not coming out clearly and they are coming out like explanations, then it confuses the drafter. A model law actually helps you sometimes even to copy and paste because they're so well written, they're flowing so well. So to me, I have a bit of a problem on that and in the way they are couched, the way the provisions are couched. Instead of following the SADC PF's mandate, which is to promote inter-parliamentary convergence and to develop legal norms that benchmark best practices. The model law on prison oversight doesn't really come out clearly on that. So it does not really equip Parliament with clear powers, duties, and tools to demand accountability from the executive for protecting the rights and health of people in custody, as this must be a clear guide. It's a toolkit, it's a guide to help them do that. And if it's not in there, it's not incorporated in the nomenclature, in the words used, then it becomes very difficult. So that's my main problem when I was trying to quickly read it. I find that maybe you'll be able to clarify as we go along. Yeah, thank you.
So just to say that the people who are being consulted right in the beginning before there'll be a model law at the end of October that goes for public consultation, right? Where people do submissions and all of that. In this month where the technical working group and other peoples are being consulted, the focus is on what's the content that we need. Not so much the wording, because we know legal drafters like yourself is going to come in at a later stage. So for example, in the beginning of different sections, let me give you an example, there are words like paragraphs sometimes in italics. Now the purpose of this sort of italics part, this won't be in the actual model law. What this is it's taken from the position paper to explain what the position paper had concluded on a specific issue, which then explains why certain sections were then drafted based on that conclusion. So it's more for when we then speak to people during the consultations who might not have read the actual position paper, that we can say the purpose of this section is, and then it summarizes it, that's taken directly from the position paper itself. So that, for example, won't be in the actual model law. And then the rest is more sections of a model law, but obviously that still needs to be adapted to the SADC PF format and those sort of things. Does that make sense? And then obviously where you think there's a need for clarity, you're welcome to just say so.
Yeah. I'm understanding you, and I think I'm going along, but in a model law, it's also very important that you give guidance. And that's the whole purpose of having maybe footnotes, italics in the beginning of the part to direct either the role player or the draftsman in what to do with those provisions, right? Because although a model law is persuasive, right, to member states to incorporate or domesticate, it's not mandatory. It's not mandatory because most of them have their constitutional and legislative mandates and how far they can go. And it's important in a model law that we don't overstretch the model law. You are talking about prison oversight, and then you're going into the executive regime in prisons, because I've noticed a few things which are creeping in, which I think we need to extricate quickly, because we need to have the limits as to what is oversight and what is prison regulation. That is very, very important for both the parliaments and the executive. We don't want to reach a point where there's tension between the two and effective oversight is thereby lost. Okay? Anyway, I think you have explained it, but coming back to the preamble, you were like asking our comments on it. If you go to basically the fourth preambular paragraph, I've noticed that you have tended to mix up the actual conventions, standards, rules, guidelines, and everything in one block. It's very difficult to read. Maybe you should paragraph this and group them into what the standards are, the rules, and the guidelines. And it will be easier even for a drafter or parliamentarians to follow what requirements they must incorporate or follow in oversight. Yeah, so I'm just giving a piece of advice on that, because if I had to read it over and over to see exactly what you were trying to bring out.
Thank you, that's very useful. We've made a note of that. Anyone else at this point? Sure, then let's continue to interpretations and definitions. I don't know if we need a definition for communicable diseases, disability, all of those things. Health professional has got quite a broad definition. Under point 11, you might want to add to it, detract to it, not call it health professionals. We can come back to the definitions probably after we've been through some of the sections, just for you to have a sense of what it intended to cover. And then we can see how perhaps to amend some of those sections if you feel there's a need to amend them. Are you okay with that? Yes.
Yeah, we can leave the definitions for last until we see exactly what the extent of the model law will be. But two important clauses that you have left out is the domestication. Under the general provisions, the domestication of the model law and the application and scope. Because you must be clear as to the extent of domestication. If this is how it's going to appear in the model law. That's why I asked you that, is this just an outline telling us this is what you're going to do, or are these the actual provisions that we shall see in the model law?
Okay, so you are the only legal drafter in this room. So
maybe I should keep quiet.
No. So the sections I'm focusing on when we go through it is we're not going to go through all the sections, because some of them we had anticipated legal drafters are coming in at a bit later stage, where we will then fine-tune all of it based on all the legal drafters' inputs. But at this point, I'm not going to go through every section of the model law. I'm going to go through the ones relevant on health. Just to save time. If you feel we should do it line by line, I'm happy to do that also. Just not everyone here is people who's that keen on some of the more boring legal provisions, which is why I wanted to take us to the health ones. But we can go bit by bit if you wanted to.
It's okay, you can jump, but let's be very careful. It's not a question also of the drafting, no. It's the question of the content.
Yes.
The content is what is important. And if you look at what's there, those are not content for domestication or application and scope. They are more explanations. So that's why I'm raising them, not in question of drafting, because you are the ones drafting the model law, not I. Yeah, but the content, the language which you are using, unless you are saying it's a mere outline for discussion. But if this is how it's going to appear, then we have a problem.
Yes. Burma?
I suggest we just stick to the fact that it's an outline for now, and as indicated, and then perhaps because part of the consultation, I think the same issue was raised in the previous discussion during the technical working group. So perhaps just to have it as an outline and expunge certain things and park them somewhere as you go on with the consultations.
Are you fine with that? So, okay, sure. You wanted to ask? Okay, let's see where we are, so I can see what we can start off with. Official visitors. Now, I mentioned that there's normally people are designated as official visitors who visits places of detention. They include people from a range of levels, and some countries have broader lists than others. Some of those bodies are mandated to visit in any event, but it's useful to include them in a list of official visitors because then it's harder for correctional service to turn them away. There was a huge debate about official visitors at the technical working group meeting. So people felt that the only people who ought to be official visitors are those who are designated by a professional body to actually do oversight. So that you wouldn't have, for example, a lawyer can come and visit his or her client, but they wouldn't necessarily be an official visitor who does oversight, unless they are someone who is doing the oversight as a member of the law society. So the idea would be that you sort of have those sort of specificities to it. So it wouldn't be paralegals, but it would be paralegals who are linked to designated civil society organizations. There was a whole debate about what designated civil society organizations are and all those sort of things. The only question for the purpose of our discussion now is number H, health professionals. I mean, not any doctor can rock up at a facility and say they want to do oversight. But there might be individuals like district health officers who ought to be able to rock up at a facility and say they want to do oversight. Now this, who would be able to do that sort of oversight? There's different, probably ways in which health departments work within different countries. So I just wanted to pick your brain on, instead of health professionals, who would be the people that should have a formal ability in the law to be able to visit a health facility purely for oversight?
Or maybe, Anik, before
Yes.
going there, just ask them, are you interested to be visiting the prisons? That should be the starting point. If they are, how now? Can we make it that I think it should be look for more official than any individual going there? Yeah.
Because they could, like, there's a principle around the visitors committees, which is a separate section.
Yes.
And where the idea with visitors committees is that they are multidisciplinary bodies. So you can have a doctor in a visitors committee who is able to go visit a prison to look purely at health issues.
Yes.
Or a psychologist. But you could also decide that there are other people who ought to be able to go at any point, even if they're not part of visitors committees. Kitty, did you want to ask?
I wanted to know, and I'm actually not sure of what the position would be. So, I mean, if there is a designated person, like the way that there is with occupational health and safety, where you have officers who are designated to go and check out various working environments, is there a specific health official that's designated to check out health facilities more broadly? Because I would imagine then that kind of level of person would be appropriate.
Yes, thank you for clarifying That's the question we're asking, yes. Is there a specific person? Lucas?
I think when it raises the issue that I discussed with colleagues earlier this morning is who are those health professionals and what are their powers? Because if I take the South African case, the nurses that you find working at a prison are employees of the Department of Correctional Services. They are not employees of the Department of Health. And that creates a problem because it would not be too contentious to assume that the nurse employed by the Department of Correctional Services is perhaps not as independent as we would like that person to be. So it then speaks to the issue of effective oversight, because a nefarious department may say, but we have health professionals visiting, but they don't say, well, we're actually employing them. And that's the problem. So I think one can take it a little bit further in terms of how we describe this in terms of functionality and powers. Thanks.
Okay, sorry, following up on what the last speaker was saying. When you look at this category, which is a list of persons who can be termed official visitors, I think we may be bringing confusion into a very sensitive institution, such as prisons. That institution is a security institution. Let's be frank about it, right? So the persons who enter that institution must be properly recognized or grouped in such a manner that will render security non-compromised, if you understand what I'm saying. So if you're talking about lawyers, yes, lawyers have a role to play. They visit prisoners to ascertain the status of their clients, okay? And not generally as official visitors. So the official visitors, if you look at the Zambian law, it's a very modern piece of legislation which complies with all the international instruments currently, okay? You'll find that they are restricted to a number of groupings, human rights organizations, justice of the peace, magistrates, blah, blah, blah. In this list, lawyers should only be categorized as official if they come through the law associations.
Yes,
the associations.
we mentioned that. We did say that.
Yeah, that's how you should categorize it and it must be categorical, not examples of.
No,
you have to state in the law, in the model law, that the following shall be recognized as official businesses. Health, what you call the one you were just saying, health professionals associations or health professional services. They've got a service of their own and so forth. So we need to categorize all these. They cannot be generalized. This is a security institution that we are talking about.
Okay, now,
so that's my advice.
Yes, no,
let's not generalize.
That's exactly what the technical working group said as well, which is why I'd mentioned earlier on that it would be people who are designated under the association as opposed to individuals. And specifically for with the oversight mandate, I think each of these people in this list comes from one of the official visitor lists in SADC countries. So some SADC countries have chosen to go broader. Swaziland has traditional leaders. I'm just saying, so some countries have decided to go broader than others. So we based it on what is in the existing legislation. When we then fine-tune stuff, we'll make it more specific. The question I'm asking here is purely as it relates to health professionals, because that's the discussion, yeah.
I think I want to get back to the question that Kitty asked earlier. I believe that it's a very important question, because in a model law, you want to improve and look at a best practice that you think will unlock something that could be done best, particularly in the context of oversight. So is there an equivalent in our countries or elsewhere that we could look at and recommend as progress for oversight to actually be leveraged? That's the question that I think we should ask. And then in terms of the composition, I think that should be left to every country, depending on the context.
Can I ask any of our doctors here whether they are, or health department people, if there are specific people within a health department that ought to be able to visit prisons?
Not health, broadly, a
Or
mechanism.
more broadly, Dr. Magwende?
Yeah, I'm getting more confused now. But I think one speaker here mentioned the conflict that exists among health workers employed by correctional services. Because remember, once they are employed, they are ranked. So the medical ethics and the institutional discipline come crashing. I recall when I was working as a director of health services, the system expected me to see my clients while seated on the floor, even if there was a spare seat. And I could not allow that because that conflicted with my ethical approach to the practice of medicine. So eventually the system started noting that if Dr. Magwende is coming, because what I used to do, if I find such a situation, I would ask the officer in charge to get a seat for the prisoner. And that is an abomination in prison setting. An officer does not save a prisoner, but I had to make it that so that a message could go. So when we expect these professionals to more or less play a role as advocates for good practices in health provision, they are compromised. Because you find that a number of officers that are superior to them are not professionals, are not health professionals. My contribution, I think, should be that district health doctors, district health directors in the medical practice should be part and parcel of individuals that should be classified as official monitors of how the health sector is being, because each district has one or more prisons. And I'd also want to submit that, like in Zambia, we have the Health Professionals Council of Zambia. This is an institution that is tasked to basically authenticate a facility to be a healthy health service facility, health facility. They tick boxes to say, oh, you have this, you have that, therefore you can act or render a service as a health facility, a clinical hospital. So this institution is well placed, like in our jurisdiction, to actually monitor and evaluate prisons in terms of health service provision. Thank you.
Thank you very much. That's very useful. I suppose I come from a specific perspective. In South Africa during apartheid, it was very hard to visit prisoners. And I think it's useful when we think about the model law to not just think about in ideal conditions. You know, like you saw how suddenly in the US things changed to an authoritarian state very quickly. And in that context, see, the prison can always address the safety issues, if there are safety issues with visitors. But the more we limit who can go, the more we're setting ourselves up for in the future not being able to have the oversight we need to have. So if you end up in a situation where the government does not have a designated oversight body, they don't have an independent NHRI, or they're not giving the NHRI any money to do their work, judges are not independent and they're too overworked to visit prisons, then you need other people to visit prisons. And you need to create a list that, as much as one wants to be specific, we just need to think about if all else fails, what other sort of openings do one then create for things to go? Any other comments? Yes.
Sorry, I don't know this body at all, but I just noted that South Africa has a health standards compliance
Yeah.
body,
Yeah.
and I assume other countries have that. Wouldn't that be a relevant body rather than the Health Professions Council?
We'll add that in, and there's also an Ombud for Health. Yes. Angola?
Muito obrigado. Sinto que essa lei modelo vai criando necessariamente algumas dificuldades no entendimento. Há alguém que levantou a ideia se trata de uma lei modelo ou uma diretriz, e eu também fiquei com esta sensação. Mas eu podia responder à questão sobre se os profissionais de saúde podiam ou não exercer a fiscalização. Antes, gostava simplesmente de colocar a posição de que a fiscalização implica imparcialidade, que é correlativo à neutralidade. A nossa realidade em Angola, apesar de nós termos vários centros prisionais, temos um centro prisional que nós chamamos que é hospital-prisão. Dentro do estabelecimento prisional há um hospital, e os profissionais de saúde que exercem a sua profissão lá dentro são funcionários do Ministério da Saúde, não são propriamente funcionários do Ministério do Interior. E segundo, cria-se sempre muita dificuldade em relação à fiscalização, porque dentro do aparelho do governo há uma questão muito importante, que é a conservação da informação, e muitas vezes incentiva-se a não publicação de determinados resultados, de determinadas realidades que acontecem no interior das cadeias, tendo em conta a ideia de preservar a boa imagem do Estado perante as organizações internacionais. O que eu acho que seria importante, alguém também terá afirmado, que provavelmente deverá ter-se necessidade de vermos a classificação de uma associação dos serviços de saúde. Uma associação dos serviços de saúde que sejam neutras aos aparelhos do Estado, quer elas sejam ou o Ministério do Interior ou o Ministério da Saúde, sejam neutras dentro dessas instituições e que haja uma relação direta com o fórum parlamentar da SADC. Isso olhando também para a estrutura de concretização, porque no princípio falou-se que haverá uma necessidade de se criar uma agência nacional de fiscalização, ou uma agência de fiscalização. Então, a dependência, nós temos que olhar para a dependência desses operadores, desses profissionais de saúde, a quem eles, qual é a instituição que eles terão a distrito, a quem eles terão responsabilidade de dar informações de muitas realidades que eles conseguirem verificar no interior dos centros de saúde, que muitas vezes estão dentro dos serviços prisionais. Então, aqui é uma questão de competência, porque as realidades dos países vão sempre divergir. Então, nós temos que olhar para cada realidade e depois criar um modelo único, porque em termos de fiscalização, parece-me, para mim, eu trabalho, aqui, por exemplo, não está mencionado uma categoria que achava importante, apesar de que os advogados, como feito referência a alguém que tem um interesse, na lógica da fiscalização, também podia ser pessoas desinteressadas, ou, por exemplo, pessoas que promovem os direitos humanos, um advogado dos direitos humanos, especificamente, não propriamente um advogado que exerce a sua profissão e tem o prisioneiro como o seu cliente, mas um advogado de direitos humanos, por exemplo, que trabalha com as instituições internacionais, que tem essa categoria. Então, seria importante. Então, quando olharmos precisamente para a fiscalização, temos que olhar para a questão da imparcialidade e neutralidade em relação às estruturas do governo que já existem. Obrigado.
Thank you. Yes?
Thank you very much. I think my contribution is a bit more or less the same as that of my colleague over here. I think we should be able to differentiate between oversight when it comes to health professionals, oversight and supportive supervision. In my country, we have our own health professionals as a correctional service, but all health issues and services, delivery of health care in the whole of the country, including correctional institutions, remains the custodian of the Ministry of Health. So the health professionals from the Ministry of Health, whenever they visit our prisons, it's because they have to do supportive supervision so that we do things the right way. Because if things go wrong, then it becomes the problem of the Ministry of Health. They have to be held responsible. Why are things not going right in correctional institutions? So I think any health professional who comes to perform a function of oversight should not come from the Ministry of Health, but at least should be part of an oversight body that has been established specifically for that purpose. So otherwise, those who come from the Ministry of Health in their capacity as district health inspectors, district medical officer, or district health management team, they should be doing supportive supervision as opposed to oversight function. Thank you.
Thank you. Yes, Humphrey.
Thanks, Anneke, and thanks to all the colleagues that I have shared. I have a different perspective altogether. I come from a different environment. I work in health care services, and I've worked for quite a long time. And in the evolution of, healthcare programs, and particularly speaking to HIV programs, we're seeing clients that are coming to access services for prevention. So these are people that are well, are not ill, but are seeking services because they need to prevent themselves from getting ill. And these people can find themselves in and out of prisons. And the way prisons would interact with these individuals would be very different from the way you would be interacting with a client that is maybe on treatment, that is on ART, that is on PPMS, that is on medication for any other condition. And I hear colleagues talking about oversight and, the international eye. All this oversight is done for the benefit of the beneficiary who is a prisoner. And in all this oversight, I don't hear enough our investment to ensure that the person who ought to be benefiting from these services has a say in how they are implemented or in how they perceive them, so that they give or they're empowered to share what works and what doesn't work. Because we really are talking about prisoners as passive recipients of care. I could be in prisons, but I'm interested in ensuring that I have access to the modern treatment on pre-exposure prophylaxis, but that may not happen. And I may not have a system to complain because, another system that, that governs how practically prisons work on a day-to-day basis does not prioritize that. So I just wanted to share that kind of anecdote and that kind of shift of what we are seeing in some of our healthcare spaces and how that monitoring could be looked differently. I haven't crafted a model law before and I'm not a lawyer, and I've just took this opportunity to share because I'm getting a bit lost of what is relevant and what isn't of.
Thank you, Humphrey. That's really useful. I think when we get to the section on vulnerable groups, we'll go a bit into, I think, the point you're raising about hearing different vulnerable groups' voices around the treatment they're getting in prison when people do oversight is very important. And we'll get to that point. Just while you were speaking, Humphrey, I was thinking that, you work within health services, but on key populations. And it raises the point, actually, that when we think about which type of people ought to have access, it's not just people like who ought to be official visitors. Perhaps it ought to not just be health professionals, but people who work in the health sector. And perhaps it ought to be people who work with different vulnerable groups because they would be able to look at very specific things when they come. So perhaps someone like you, Humphrey, ought to be an official visitor, to go to a prison purely to look at how key populations are treated. If you get what I'm saying, perhaps we need to just think about, are we even limiting ourselves in terms of what would be best practice? If I go to a prison, am I equipped to do oversight to see whether people with mental illnesses are treated properly? I don't have, I'm not. So then how do one think about that in a way that the people who do go and do oversight, how do we make that broad enough for people who will have a specific interest in particular groups to also be able to go and look after those groups' interests? Yvonne, you had a hand up?
Thank you very much. And I'm thinking now, so when a problem of when any problem is raised about prison conditions, I'm asking myself, as a former member of cabinet, when a report comes, either a decision of a court or a decision or report from, let's say, the African Commission on Human and People's Rights and or civil society organizations coming to say these are the conditions, this is what we are complaining about, or even an inmate writing to a member of the executive. I've received a number of complaints from prisoners themselves about access, about whatever conditions they're finding themselves. Now I'm asking myself the question now, is it, so who should react to that complaint in whatever form it comes? And I'm sitting here thinking, what would be the role of a health professional, regardless of where and who the author is that is sending them to go and investigate? And I think that's the point from which we really need to think about this. Who has the primary responsibility to protect the integrity of correctional service facilities across the spectrum, right? And so if we think about it practically, I'm wondering whether even having health professionals, on a list, whether that is the appropriate thing to do and how countries would react to it. So I don't have the answer. I'm not offering you the answer, but I think we need to think about it from the point of view of responsibility and oversight. It would seem to me that if you look at the three key stake organs, including parliamentary oversight, that would be where responsibility lies. And so the long list that we have would be institutions that may not necessarily have to access. So I would, have reduced that list even quite significantly if you were to ask me. Just talking about what is a correctional facility. So maybe let's think about primary responsibility, and under that primary responsibility, who would be your actors that would be used to facilitate prison visits for purposes of determining whether or not they meet the norms and standards that are required.
Can I ask, just linked to that, Yvonne, so you have obviously various people within government who have certain mandates, both within the executive and within the judiciary and the legislature, who have certain mandates around oversight. And you can definitely categorize those and say, okay, they're official visitors. But say, for example, but to what extent would you include civil society oversight? And how would one conceptualize that? Because civil society might not have an official mandate, but without the civil society oversight, you often miss a key element of prison oversight, especially depending on the situation in a particular country. So I'm just flagging it that, yes, we need to categorize, and that's what was discussed at the previous meeting as well, that we have to categorize that those people who are mandated are the ones who can go do visits at any time. But other people, like international organizations, civil society organizations, whatever, would be able to visit, but they need to apply. Or, there's be a different process for them versus for the those with official mandates. So I'm just flagging it. So official visitors it's a short section, but one that everyone's got views on. Yes.
Sorry, following upon what Yvonne is saying, I think what she's saying is very, very important, because everything is tied to the issue of oversight, parliamentary oversight, to emphasize. So when we are dealing with institutions that will have the role or the mandate to do that, automatically, because I don't know why I keep saying these are sensitive issues, we have to incorporate into the model law the process of entry, reporting, and what you call feedback. So when these reports are done by these oversight authorities, and your paragraphs indicate that they have to submit this to the correctional services, the head of the correctional services, what does that person do? That person must be given definitive time periods to respond to the issues before you can even go online, as is indicated here. They must be published online. I don't think that's the way to do things. That's now a recipe for confusion and a recipe for a fight between civil society, executive, and parliament. A process, definitive process, that should, to me, end with parliament. Parliamentary oversight becomes imperative, so that they check whether the executive is following the laws, on minimum treatment of prisoners and their healthcare. Without the process embedded in here, it will not find its way into the national legislation. So we need to refocus this whole part, because I've seen even when you're dealing with the issue of visiting judges, it's not very clear as to the process. You see, if for visiting judges, you haven't done it for the other category, you've done it for visiting. So the head of the correctional service must implement all relevant recommendations and suggestions from duty officers. But that is at what stage the question will be asked. Because following there, immediately thereafter, that is 2. 3, you actually state within 1 week of the visit, the visiting justice must submit a written report to the head of correctional center and the Commission of Correctional Services of the findings of the visit. But that needs a process of commentary, actions to be done, remedial, whatever it is, and then only can the recommendations be acted upon. That is oversight. But without process, there will be no action, there will be no implementation, and there will be no oversight. So the process must be embedded.
Yes, that's so. At the moment, the model law really takes from what is in existing legislation, and you're absolutely right. And this is what Lucas explained with the position paper, that the information that gets collected by various oversight mechanisms and the information that ends up before Parliament is but a fraction of what was collected. So information gets filtered out of the system, basically. At the moment, all of our laws says that visitors fill in the visitors book. The head of the facility looks at what the recommendations were made in the visitors book, then tries to implement that. Depending if it's like a really horrible head of the facility, they're not going to care much about what the visitors said. And when they report to the minister or the Department of Correctional Services, they're going to say, you know, we never get any complaints. It's a great prison. Everything's going according to plan. So, like you say, the problem is that we rely on individuals, and without the process, you can't assume that the right information is going to get to Parliament. Now, at the moment, that is not in any of our laws. Some places they have it in regulations a little bit. And that's really what we need to figure out here, is about what is feasible and what is not feasible. And for example, that's why in some countries they have decided on publication of reports precisely because information gets filtered out within government itself. Because within government, government is only going to collect the information they want to collect about how great they are. So, and that's why some oversight bodies have decided we publish online everything. That's why some oversight bodies decide immediately after the visit we publish our recommendations, and then they also publish the government's response to those recommendations once they get that. And then they would publish after that their follow-up to see whether the recommendations were implemented. So there's different methodologies, and I think countries who have done oversight for a long time have learned from some of the limitations within those processes. Lucas?
Yeah, I mean, I think this is, it raises interesting issues, especially around judges, because judges are judges. But we must remember that the purpose of monitoring, in the sense that we're talking about it here now, is to establish a basis for dialogue. In other words, a judge comes to visit the prison, he makes or she makes certain observations, records that, shares it with the Parliament and with the head of centre, and it becomes a basis for dialogue. That is that basis that underlies the optional protocol on the Convention Against Torture. It is not an end and a finding in itself, but rather a process to start a deeper dialogue, to focus on long-term objectives. So I think we must be mindful of the realities of the situation and how we establish a dynamic process, and not say, okay, well, you know, one finding must be absolutely proven beyond a reasonable doubt now. No, that's not going to work. Let's enable a dialogue to happen. Thank you.
I'm asking myself, you know, to what extent should sitting judges visit prisons, for example, when they are likely to be seized with a case that would involve, I mean, Namibia had decisions where, you know, prison conditions were actually declared unconstitutional. What then happens? What's the consequence of a court declaring a condition of prison unconstitutional. I remember the particular, client in that case wanted to be released because the conditions are what they are. But I'm asking myself, should sitting judges visit prisons unless it's part of what we would consider inspection in loco if of a particular case. So I'm very, very conflicted about sitting judges visiting prisons. I don't think they should, but I think there's been a practice maybe to have, unless it's part of a commission of inquiry that has been established into the conditions of prison. So I just wanted to raise that as part of the conversation that we should continue to have.
Just on that, visiting justices are the longest standing practice of prison oversight, going back centuries. I think every judge should visit a prison. Why? Because how can you send someone to 10 years without knowing the conditions you're sending them to? And judges might say, yeah, but I'm just implementing the law, but you can't send someone to cruel and inhuman treatment or impose a sentence which in some countries a 5-year prison or a 1-day imprisonment is the same as in other countries, just in terms of the pure inhumanity that you would experience. So I do think judges have a responsibility to know what's going on in the prisons. But apart from that,
sorry, I'm sorry to interrupt you, but is that true for if judges make decisions about the conditions in which people live, for example, if they make decisions about demolishing corrugated iron sheet houses, do judges actually think about what are the conditions in which people live? I think, so I hear you, but I think that we need to really think about the philosophy behind it.
Yes,
Sorry.
so my point was just this, that the more important reason why judges need to visit is that, okay, in some countries like Malawi, if a judge goes to a prison, they're actually able to release people because they can see people have overstayed their detention or those sort of things. So some countries give judges more power. In countries where there's immense overcrowding, like in most of our countries, it's important for judges to see how many people are sitting in prison even though they've been granted bail because of the high bail amounts, how many people are awaiting trial because the judicial system isn't moving fast enough, like those sort of things, because, and you're right, it doesn't have to be all of the judges, but perhaps the head of a prison, the head of the judiciary or the senior magistrate, but someone needs to see the impact of the judicial system on the prison system to be able for them to work interchangeably. More input? Yes, Mauritius.
So I'll give some comments about the health. I think if we all here today, it's mainly for the progress. I agree with all the health professionals here that we do need to have the group of health professionals who will visit and assess to be from a neutral body. Because like in my country, I work under the Ministry of Health, but my fellow colleague who works in prison, he is employed by the Ministry of Civil Services. Everything is totally different. Even the salary, work condition, everything. For me, prior to coming here to do a field work was so difficult to get information what's happening in the prison was very, very difficult. I couldn't even get the phone number of those doctors. So I'm thinking about if I had to go to visit, what would be the process and everything. But secondly, if we think about progress, I would say that those health professionals should be affiliated to an international body like WHO, which set a guideline, and those should be trained in QI, quality improvement. There are many courses being dispensed nowadays in QI, and it's very easy. It's like checklist, like the prisoner came in, that mission, he did a screening, at 6 months this happened, and sometimes you don't even need to go to the prison, you have access to the files, because you're doctor, you can access to the file, you can compute everything from the file. you can catch where we went wrong and then give a report recommendation if we can do this. I'll tell you a story about a woman pregnant who used to come each time we say, I'm having low backache, low backache, low backache. Okay, pregnant, low backache. But when we took a proper history, she was not having access to milk at all, milk products. So calcium was very low. So on that QI, we wouldn't go like, would the prisoners were given cheese or no. Our QI would be low backache in pregnant. When they had this, what was done to improve? So then we can recommend. Like, we're not here to pinpoint our fellow friends there that you're not doing your job right, but we are here to tell them we could do this to improve. So I think the health professionals should be affiliated to international bodies who set guidelines so that everyone works standardized and to be empowered with QI courses so that everyone benefit.
Thank you. I wanted to make 2 comments. The first one on the visiting judges. When they do visit, for instance, in the Kingdom of Lesotho, they have helped us a lot to deal with the ever-growing population of untried inmates and to unlock some bottlenecks in dealing with some specific cases where you find someone has been awaiting trial for so many years and nothing has been moving. So they have actually helped us to deal with such issues. Now, another comment is on the process leading to the publication of the report of any oversight body that comes into an institution. My understanding is that they don't have to seek permission from anyone to come and see a correctional facility. But once they have done that, my understanding is that there should be a signing out kind of meeting with the authorities to say, this is the situation that we find in your prison. What are your comments on this? So that we have the opportunity to first clarify some of the issues before they are publicized. So I think, in my view, as it has been discussed, that process should be clarified as to how do they come in and what should be the process before the report is publicized. I'm afraid if we don't do that, then we run the risk of sensationalizing some of the issues that are found within the correctional institutions, some of which may not necessarily be true. You know, when you interview inmates, they never ever tell the truth about prison officials or the department itself. So you still have to clarify some of the issues with the officials or the highest authority responsible for correctional institutions. Thank you.
I can't say I don't think we can say prisoners never ever tell the truth, but so point of order with that remark, but I get what you're saying. There was a comment there.
Thank you. So what I hear from colleagues is that, one, the institutions that are responsible for upholding the minimum standards and conditions for prisoners have the duty to make sure that they do that, which is one. And then I do think that the oversight body is just now coming in to see and give a perspective on whether they're doing that right and if there are any areas of improvement, not to police or shame, but just to make sure that, there is someone who is giving you an external perspective on how you are doing and how you can improve things. And then lastly, to say, I do agree also that recipients of care are a very important stakeholder. And maybe instead of listing who should visit and do that, we can look at the composition of the oversight body so that it is very diverse and can represent all the relevant stakeholders that need to provide that oversight. And I think in these discussions, it is reminding me of what is happening in my country, where you'll have senior officials that are tasked with these responsibilities all the time. They would be saying how things are being done properly and in the right way, and that they have procedures and processes and everything well covered, and that they are aligned with international protocols. But it did happen that one of them ended up in jail. And right now, he is the person who is writing letters left, right, center to everyone who can listen about the deplorable status of our prisons. So I do think that each one of us has a role to play, and we should be in collaboration. We should be with a shared vision of what is it that we really want to achieve, and making sure that people, live in dignified conditions in prisons. Thank you.
Our colleague from Mozambique.
Tá, muito obrigada. Em parte, fiquei ligeiramente ultrapassada com o pronunciamento de Lusoto relativamente ao que os relatórios trazem em termos de informação. Mas gostava aqui de partilhar que, dentro daquilo que é a nossa Constituição da República, o Ministério da Saúde é que é o responsável pela saúde de toda a população. Daí que o Serviço de Saúde Prisional, Moçambique, é um subsistema do Serviço Nacional de Saúde. Então, mesmo que o enfermeiro ou o médico que esteja a trabalhar no centro de saúde da penitenciária seja um agente da guarda penitenciária, ele é regido pelas normas do Ministério da Saúde, independentemente daquilo que ele tem como formação como guarda. Eu queria falar sobre isso, sobre a questão de supervisão dos serviços de saúde dentro das penitenciárias. Para nós, como Moçambique, a supervisão é feita o Serviço Nacional de Saúde em conjunto com os serviços prisionais. O Serviço de Saúde não vai somente à unidade penitenciária para poder fazer a supervisão. Isso ajuda não só a população reclusa, como também aos próprios funcionários, no sentido de poderem melhorar aquilo que é assistência dentro dos estabelecimentos. Relativamente à visita dos juízes, não sei qual é a realidade dos outros países, mas para nós, o juiz, quando vai à penitenciária para fazer a visita, não vai no sentido de olhar qual é a condição que este recluso tem. Vai, mas sim para procurar saber quantos é que foram julgados, quantos é que estão sobre a prisão preventiva. Então, não sei se esta lei que nós estamos a criar, ou o modelo de lei que estamos a tentar criar aqui, será uma lei vinculativa ou não. Porque se não for vinculativa, cada país estará a fazer o que bem entender, digamos assim, e que estaríamos aqui porque já tivemos reuniões anteriores. Eu falo isso porque já houve POPs que não foram cumpridos em vários países. E nós hoje estamos a falar sobre uma lei modelo, que eu não sei se esta lei será uma lei que vai obrigar os países a poderem cumprir. Estou nos serviços penitenciários há 14 anos, eu sou do Ministério da Saúde, mas são poucas vezes que eu vi os órgãos parlamentares a visitarem as nossas penitenciárias. Então, estamos aqui a falar sim, mas eu não sei se os parlamentares do meu país estarão em condições de poder cumprir com aquilo que esta lei quer. Muito obrigada.
Thank you. So just on that point, the section on official visitors doesn't mandate people to go visit a prison. It allows you to go visit a prison if you are on that list. So the same applies to judges. It's only really NHRIs and independent prison oversight bodies that are mandated, that have a legal obligation to go visit. But what one would want is that you would want other groups who also have oversight to also visit, but it wouldn't be in the same as frequently, and there'd be lots of other changes to it as well. So this isn't necessarily about dictating how often members of parliament must go visit a prison. It is useful for them to see what they might end up if they are corrupt, so that they, as a deterrence for members of parliament, perhaps they should all go visit prisons. But okay, that aside, Lucas, you had comments.
I've got two quick comments. The first is on the judges. And to some extent, I shared your conflict. But then we must also remember that judges or magistrates, they are ultimately the custodians of the right to a fair trial. And in my view, that extends to protecting the accused from abuses, but also in the fairness of the punishment. So in that sense, for me, there's almost a natural mandate that flows to the prison. How one regulates that and rules of recusal at trial and so on, I mean, that's other things, but I think if we can accept that, and that comes from the ICCPR. So that's the one point. The other is a more general comment that when we are conducting prison monitoring visits, and here I'm talking specifically about the actual visits, I think it's very clear that that visiting mechanism or individuals are very clear, upfront, and transparent about what they are looking at and what they are looking for, and how they interpret evidence. So for even a basic thing like access to water, how do you operationalize that? You say 2 liters per day, water always, but that the officials must know that this is how I am going to interpret that standard. Because you don't want a situation where there are attempts to hide the truth, which is almost natural. So be upfront, be clear, be transparent. What is the standard? What am I looking for? What is the evidence? And I think that helps a lot with oversight. Thank you.
Any other comments? Dr. Magwende, and then afterwards a colleague from Angola. Yeah.
Yeah, I think we need to introspect why we are here today, almost 300 years of prisons as we know them. I like thinking that probably the issue of prison settings generally is usually on a blind spot. Because I recall when we are growing up as kids, we are taken to a hospital as kids to know what a hospital looks like. A shopping mall, you go to that. You go to a police station and all that stuff. Back home in Zambia, I never experienced in my 5 years at prison where kindergarten kids came to visit a prison. And I saw the results in my working life, where you have not once, not twice, many times, town planners planning a town and they leave out a prison because the prison setting is on a blind spot. When you look at other institutions like schools, for example, They are already past this point decades ago. When you look at hospitals, generally, they are past this point so many decades ago. But with prisons, this is when we are cracking our heads over this. Why? Because it was never thought of. Prisons are never thought of. Prisoners are never thought of. When it comes to who should have the responsibility to look after the minimum standards, I believe it should be everybody. Because we don't choose who should have the responsibility to see that, oh, this school is in good condition. If I'm a parent, even if I'm not a structured institution to complain about that, I'll have a way of complaining. Everybody should have the responsibility to look after the conditions in prisons. Yes, I do agree with the need to structure who should and how the concerns should be taken on board. We should, of course, focus on those that will unlock the bottlenecks, those that will have ameliorate the conditions, the discomforting conditions. We need to look at those institutions that will alleviate the challenges that exist in prisons. Otherwise, we should have gone past this point a long time ago. So in our own respective responsibilities that we have back home, it's very, very important to ensure that the issue of prison and prison settings is incorporated in one or the other in these kids, so that as they grow up with the responsibility that apart from a hospital, apart from a school, apart from a park, there is a prison as well that should be looked at as one of the institutions within our environment. Thank you.
Thank you. That's it's a very important remark. And I read the other day that they were trying to ensure in Mozambique, I think, where visitor committees, where the people who go and do oversight of a prison is the people who stay within the area of that prison, so that people actually take ownership of the conditions and that the prison is then regularly monitored. So when we look at oversight, there's many different ways in which one can look at it. And for example, in many countries, there are district health committees. So it might be that issues around health at a prison you want to go raise at a district health committee. Or, there's so many ways in which we can intersect that we know isn't happening at the moment. And I think it's an opportunity to also think creatively about how we do that. Colleague at the back from Angola first, and then Eswatini.
Obrigado. Eu estive a pensar em todas as intervenções e principalmente quando falamos em relação à fiscalização e olhamos também na questão da fiscalização feita pelos juízes, e a intervenção que me antecedeu apresentou um pensamento muito interessante que até agora os países africanos, em relação ao tratamento das questões dos centros prisionais ou do prisioneiro, continuam com a mesma mentalidade da anterior, aquela mentalidade do tempo colonial, né? Ontem as cadeias eram típicas, efetivamente, para os escravos. Hoje o cenário mudou, mas as cadeias hoje é mais para as pessoas pobres, a realidade do meu país, porque em Angola as pessoas que estão nos centros de reclusão são aquelas pessoas que roubaram botija, galinha, telefone, pronto. Então, e muitas pessoas também de crimes altamente perigosos, de assalto, mas é tudo para a sobrevivência. Os crimes de colarinho branco, que nós chamamos crimes patrimoniais, corrupção, normalmente vão parar no centro de reclusão, mas em centros mais especializados, que apresentam serviços que têm mais qualidade. Por exemplo, o centro que vos falei, que é o centro prisional, hospital-prisão, que dentro desse centro existe um hospital-prisão, normalmente é um hospital de pessoas que tenham cometido no âmbito de funções políticas, que sejam ministros, filhos de dirigentes, ou governadores, ou deputados, então vão lá ficar um hospital com mais condições. Então, a criação dessa lei modelo vem na necessidade de criarmos a ideia de que o direito à saúde é um direito de todos. Não é um direito apenas daqueles que têm, mas é um direito de todos, é um direito fundamental. Então, se construirmos a lógica de que seja um direito fundamental, vamos perceber que em relação a um âmbito da fiscalização, ele deve ser alargado. Não apenas restringir para juízes, procuradores, mas está-se a perder, por exemplo, aqui em África, a sociedade civil vai deixando de ter um papel muito importante, porque os governos agora querem controlar todos os espaços. Muitas agências das Nações Unidas, como o PNUD e outras, privilegiam o trabalho com o governo em relação à sociedade civil. E a sociedade civil não consegue exercer o seu trabalho comunitário também por falta de financiamento e apoio. O que eu acho é que a ideia de Moçambique de contemplar a fiscalização aos munícipes, às pessoas que vivem ao redor, e também a outros atores que não tenham interesse propriamente no processo, nós estaríamos a criar um processo de humanização e um processo de inclusão daqueles assuntos que anteriormente tínhamos a concepção de serem problemas sensíveis, porque a sensibilidade que durante muito tempo nos foi incutida está na ideia de preservação da comunicação. Ou seja, no governo a lógica é que a informação não pode sair fora. A informação nós não podemos reportar, por exemplo, que seja o parlamento da SADC, porque estaremos a expor como é que nós trabalhamos. Nós temos, a nível da nossa estrutura em Angola, a criação dos juízes de garantia, que foram criados para garantir direitos fundamentais na legalização das prisões, que as prisões, apesar de elas terem sido efetuadas, mas tem que se observar os procedimentos de garantia de direitos fundamentais relativamente à saúde. Existem presos que são espancados pelos órgãos de segurança e às vezes têm ferimentos graves e eles não são submetidos a um tratamento, são logo, por exemplo, encaminhados para um encarceramento sem o acompanhamento psicológico. Existem presos que de facto são doentes, mas não têm esse acompanhamento psicológico. Então, são essas questões que nós temos que olhar, que é preciso alargar o âmbito da fiscalização, mas principalmente olhar para esse modelo de boas práticas relativamente à inclusão de outras pessoas que não têm interesse, cujo interesse é apenas ver uma harmonização, né, de vida do próprio recluso na ideia de concretização do direito à saúde, porque aqui é extremamente fundamental. Olharmos para a realidade, em Angola, existem quantos centros prisionais que de facto têm um hospital dentro da cadeia. E porque temos que pensar que muitos países africanos, a saúde já falta para aqueles que estão livres. Já há uma superlotação dos hospitais, não existe. Quanto mais para o recluso, porque o recluso por si só já é uma pessoa vulnerável. Então, penso que é nessa lógica que temos que continuar e eu acho que, apesar de estar lá descrito essas entidades, mas temos que olhar principalmente para pessoas desinteressadas.
Just to add on to that, all of our countries were affected by the PEPFAR cuts, especially HIV services and those sort of things. And it's actually very hard to find out how those cuts impact prisons, because people can't get the information they need from prisons. So the issue about oversight is very critical. Now, those people in the prisons who might not be able to access their antiretrovirals or other medicines or get tested for TB are the same people who are going back into the community. So the community does have a vested interest in what happens in prisons. And it's their own sons and daughters also. There was a big debate in the technical working group about traditional leaders and whether they should be allowed access to prisons. But then it goes back to what sort of access and how one would limit it and those sort of things, but recognizing that there are groups of people who are also looking at people's reintegration back into society and would want to know what their experiences were while they were in prison. Yvonne, I'm taking your hand.
Just maybe a quick one, just to be clear that in Namibia, in fact, recently, before my term ended as minister, I'd actually visited a prison with the Chief Justice. So it's not an unfamiliar thing for judges to visit. I was just, reflecting on my own conflict around that. But I am really resonating with what the good doctor was saying about whose responsibilities it is, and also my colleague from Angola. And I'm wondering whether the way in which we are casting oversight may change the perception that prison is not about, or rather oversight is not to see what we're doing wrong, but rather that we have all a responsibility as the community collective or as a societal collective, like the doctor was saying, to make sure that we have that community is also taken care of, and there's that aspect of humanity. So I think when, again, I'm speaking as a former member of cabinet to say that the moment we hear oversight and surprise visits, the thinking is they're trying to catch us out. And so it really changes how that interaction works. And I'm wondering whether the language in a model law shouldn't rather be to try and see that this is our collective responsibility. We're not trying to catch anyone out. How do we improve, the situation of health, if you'd like, in prisons as a collective? So maybe just recasting how we want to meet that objective.
Sorry, I forgot Eswatini. Can I do Eswatini first and then you, Boyemo? Sorry, Eswatini.
Okay. Thank you so much. I wanted to say maybe we need to be clear in terms of the different roles and responsibilities when we talk about oversight, especially because public health is a multi-sectoral approach. So I think it's not only limited to health or correctional or the different department, because we all have a certain role to play. I'll make an example for health. As much as in Eswatini we have correctional facilities that provide health services, but it is our mandate as health to ensure that those facilities adhere to the standards of healthcare provision, be it accreditation of the facilities for the purposes of providing health services or adherence to minimum standards or data quality and stuff like that. As a ministry, it is our responsibility to ensure that happens within prison. But sometimes you find that the relationship between health and correctional facilities, I'll make an example. We draft a lot of documents together with correctional services, but there are certain elements as health, you say, these are the standards as health that we expect to see within correctional services. And correctional services, you say, this is a security setting, therefore we cannot provide this and that and that and that within the correctional facility. So we need to create that balance, that because as health we can go as much, but there are other departments within government that can also ensure that correctional services, or we all adhere to our mandate and responsibilities within correctional settings. Thank you.
I think the point you raise also, actually, now that I'm thinking about it, is that when we looked at internal inspections, we only looked at inspections by correctional services themselves, not actually that multidisciplinary, the other departments and those sort of things. Boema.
Yeah, no, thank you very much for the various contributions. I think ultimately we need to zero in on strengthening the whole concept around oversight, particularly because at initiation, in view of the sensitivities that you raised, it was zeroed into interparliamentary and parliamentary oversight, so that it does not assume that we are trying to overreach. I think that's very important. In fact, it will not pass. So part of what we are discussing here, we need to ask ourselves, what is the tipping point? What is it that you want to change? And for whose sake? Let us move beyond our current constraints. And let us not assume that the other side is going to say no or yes, but what are we selling that may ultimately be something that will solve our problems beyond today? It is not a consensus law, it is a model law. So if we fail to bring to life the discussions that we have and mold them into a product to sell, we are going to discuss, and all these things that you are discussing are covered in the model law concept note. The research around why this should happen. This is sort of like to give people an appreciation that we've surveyed the land and we see what is happening. The challenge before us today is how do we package and sell the product beyond our current constraints? I just wanted to bring it up because some of these may not find their way in the model law. They'll probably find their way in discourse and not necessarily anything that can be legislated for. The concerns have been ably pulled together. The challenge for us now is what is it that can find its way into the model law? So I just wanted to bring that back because often it becomes difficult maybe for the consultants to say, okay, that we can't legislate. Yes, it's a good concern, but we can't really package it. But I just want us to just come back and say, yeah, how do we make sure that there's enjoyment of rights, as you rightly put it? How do we make sure that A, B, C, D happens? How do we make sure that the violations are not hidden away from accountability? How do we influence regulations in this regard in a manner that would improve the current scenario? Which countries around the globe or where that we can look up to and sell to the region to have as a standard for parliaments to be able to look at it? You've talked about punishment alone doesn't serve. Yes, we agree. It's in the concept note. What are you proposing for us to move forward? I just felt I should just throw these things in there. Thank you.
Thank you, Boema. I think that's very critical as we reflect going forward. I remember we had a 3-day meeting with the parliamentarians of the Parliamentary Forum in April. And after 3 days, they were convinced they need a model law on prison oversight. They were worried how they would go sell it back home. And it is really that point, and I think all of us here can identify with the point of collective responsibility and all those sort of things. But we also know back home, everyone is saying lock more people up. Lock up anyone who's not a citizen, lock up, like there's such a carceral and punitive way in which as societies we operate, and one that cares absolutely zero for the conditions in detention. Ask any person on the street, they would never even have thought about, I wonder how prisoners are being dealt with. So part of this exercise, and this is what makes it particularly challenging, you don't want to. We all know that there is great potential for brilliant oversight, right? Because we've seen oversight happen, we've seen best practices. We all know we're trying to sell this to people who don't actually care. And you want to be as detailed as possible, but not scare people off, but be inclusive and recognizing all the gaps that there are and the difficulties that there have been before, so that you come up with something comprehensive. So it is going to be, it's quite a consultation process, and I think it's useful for people to feed into the outline so that we get the content right of what we want, and then figure out how one would actually draft a model law that parliamentarians would be willing to pass. That being said, it's exactly 1 o'clock. We have lunch now, and then after that we'll actually go into, I think everyone sort of, there's been so many useful points made about what health professionals ought to be doing. We're going to deep delve into that a bit after lunch. So 1 hour lunch break, and then we'll come back here. Thanks everyone for everything. It's right on top of a shopping center. So I will be nice to you and try and get us to finish at 4. So can we start now? If you don't mind. Yeah, let's just kick off and do this thing. Okay, it doesn't look like we have a tea break, so I think we should be fine. And we can just move ahead. So, there's a few sections we have to look at. The one would be the whole section on health professionals, and then there's a section on mandatory reporting. I think we can park that for now and focus on that tomorrow morning. And then on this afternoon, we look at vulnerable groups. Because I know vulnerable groups is always highly entertaining and it's like a nice post-lunch exercise. So a few things to say here. That it's debatable whether you need a section on vulnerable groups or not. Different groups are vulnerable for different reasons, and normally the minimum standards applicable to those groups are already provided for under international laws and standards. So, for example, the Bangkok rules would deal with women in detention, women and their children in detention, those sort of things. So when we look at vulnerable groups, we're not looking at the specific things necessarily that they experience, but we're looking at whether there are specific things that might come in oversight that you would have to be aware of. So for example, if you do oversight at a facility where there are children, then you might have to think about, are the people in the oversight body sufficiently trained on how to communicate with children? If you're doing oversight in relation to migrants in detention, you might want to think about whether you have sufficient translation services available, whether those translation services are independent from the prison translation services, those sort of things. So there's dynamics specifically about oversight. However, that being said, so I want to just take you through the first section before we get to the other bits. What we have done is to try and say that we're not here speaking about specific minimum standards, but these are the minimum standards that oversight bodies should look at to make sure that they are being complied with. And I note the point about separating them in categories and all of that, like we discussed this morning. Now, in the position paper, under the section on vulnerable groups, we had a whole section on women, specifically in relation to sexual and reproductive health rights, in relation to women who are in custody with their children, or pregnant women, and women who had experienced sexual violence. The question, so we know there are lots of issues in relation to women, right? The question would then be, when it comes to oversight, do you just tell the oversight body to take into consideration all the issues around women? Or are there particular ways in which the oversight body must conduct itself so that you actually include a section on women in the oversight section? The technical working group felt that there should be a section inserted specifically in relation to women that reiterates some things. It then breaks with, but then you can say, okay, we should reiterate stuff in relation to every group, so then it gets a bit tricky. So do you say any oversight body must be aware of vulnerable groups and aware of the minimum standards, or do you actually include specific provisions that oversight bodies should consider? Now, let's leave women till the end, because at the moment they're not in the model law. Not because we don't like them. I just didn't know what to say about women that requires a different way of oversight. And I'll point this out in relation to when we speak about the other issues. So if you look at children, for example, and Doreen, I think because you were at the technical working group, if there's additional stuff that you remember people had about the conversation, just put up your hands and flag it. I mean, a lot of the comments that were made at the technical working group must still be incorporated in those sort of things. So if you look, for example, at oversight in relation to children, there were a few points made about what you prioritize in the monitoring process, and that your oversight mechanisms might want to include social workers and child intermediaries and people who are suitably trained to deal with children and to communicate with children in a child-appropriate manner. And if they are not trained, perhaps bringing in an expert in your visiting team, and that there should be, that the oversight bodies, when they go to a facility, must look specifically at whether the staff at the facility are suitably trained to deal with children. Okay, now, before we get there, just one point. Theoretically, a child should never be in prison, and the model law only deals with prisons. So you could say, well, we shouldn't have a section on children because they shouldn't be there to start off with. Although you will get children who are there because they're there with their mothers, but then they would be really small, up to the age of 4 years normally. So do we have a separate section for those children, or are we speaking about all children, assuming that no government is following the law and there are actually children in places of detention, which sadly there is. So you see, this gets all complicated, but you had a question.
Yes, sorry. So the model law doesn't apply to juvenile detention centers?
Does it? Oh, I don't know.
I mean, in terms of the definition, it should.
It should in terms of the definition. So it depends on the types of centers, I suppose, and how the children end up being sent there. And yeah, so we can say it should apply. Like I can think of many facilities in which children are, but see, children, yeah, it's a tricky thing because they ought not to be sent to imprisonment. So when they are in the facilities, they're there because the facility is a safe house or a place of rehabilitation or something actually happened and they're over a certain age. So, but that's something we actually need to flesh out a lot more. Doreen?
I'm just, in relation to that question, I am aware that, different countries have, different realities. But I think in the context of South Africa, I mean, you've got the child and youth care centers, and even in relation to oversight, JICS does not have jurisdiction over child and youth care. So JICS is the Judicial Inspectorate for Correctional Services. That's the independent oversight body for South Africa. And the oversight is technically supposed to be done by the Department of Social Development, right, for child and youth care facilities. But I am thinking, because if we wind up having the model laws looking specifically at prisons, whatever comes under this section should take cognizance of the fact that even though South Africa does not have juvenile facilities under corrections, but there are juveniles nevertheless in correctional facilities to some extent.
So just on that, it's not just South Africa. So a number of countries have adopted child justice laws. So in terms of the child justice framework, the children would then not end up within this prison system. And a different mechanism for oversight would then theoretically exist in those things. So what the technical working group debated was whether or not you acknowledge not every country has a child justice system, and therefore we include more provisions about our children, or whether you actually want to say that in terms of the international and regional norms and standards, children should never fall within the prison system. So, I mean, it's always good to err on the side of being inclusive, but one might want to just add additional provisions there on child justice. Lucas, you wanted to say?
Two comments. I think it's important that we deal with what we have. It's not within the scope of an oversight mechanism now to say children, that's my view, should not be in prison. The fact is they are there, and one needs to deal with them and make sure as far as possible that their rights are protected and upheld. The other two issues with children in prison is firstly children who are imprisoned with their mothers. And so those are infants typically. And the question then becomes if the mother is then sentenced, what happens to the child? Is there a mechanism? And what does the law say around that? Recently, I wrote a commentary on the African Charter on the Rights and Welfare of the Child, dealing specifically with this issue. And it was very noteworthy that this woman can be in custody for several years, awaiting trial. And it's only at sentencing then that the court suddenly concerns itself with the welfare of the child. Now the question is, okay, where must this child go to now? That's the one thing. The other angle to it is that when women are imprisoned, awaiting trial especially, it has an impact on the household. And we're not looking at that link sufficiently, because that caregiver is now gone. Maybe the child is 3 or 4 years old, or even 5, but there's something, so the entry point would be the women who are imprisoned with dependent children. And that's something that an oversight mechanism can look at. Thanks.
Yeah, I agree with what Doreen was saying, but what we need to look at in the model law is, yes, we can have basic minimum standards, which we will provide for here, but it's an issue of compliance. As you know, most of our statute books are riddled with legislation on the child, on women, on healthcare services, and all those. So it's the oversight will be overall to see that those laws, which already exist, are being complied with in relation to those groups whilst in prison, because they do provide for that. So we must be clear in the model law that we are not being restrictive as to the minimum standards, but we are looking at it from a wider perspective of compliance. So oversight will be on compliance. That's where I'm looking at it.
I recall the earlier discussions around the import of the model law. We actually had prisons and places of detention, but there was a logic that you came around with in terms of how broad it becomes and how it then takes us outside. Maybe if you shared that with colleagues, we would then settle the matter and see if the focus can really be there, or from a regulatory perspective, integrate something, because the concern of children keeps cropping up. It keeps cropping up, but I think we need to find a strategic way of integrating that without necessarily going outside. It could be part of the tool, probably, for monitoring to see if this is checked, and find a mechanism where that can be, there are various committees that we could look at whether countries can pick up those indicators for integrating in their normal reporting around children.
Yeah, we made the decision to focus. Sorry, your mic is on.
Oh, sorry.
And then I can't switch mine off. We made the decision to focus on prisons because there are, firstly, so many other places where people are deprived of their liberty. And that may be long-term or short-term. And technically speaking, a child who is attending school at a residence is in a place where they are deprived of their liberty to some extent. So do we include that as well? And then it becomes really complicated and complex, and even places at international airports, or there's just such a variety of places. And we thought it best to rather start with prisons, because that is where the majority of people are detained, see how it develops here, and we can always, at a later stage, expand on it. But we may just misfocus entirely if we're trying to cover everything first time around. I don't know, does that...
In the definition section, there's a definition on correctional center. What we could consider is, because there are so many different ways in which people are detained, including immigration detention and other things as well, what you can consider that probably the easiest extension would be to define it based on places in which people are detained in in relation to a court order, because then it might include mental health institutions and it might include children who are in places of detention in some countries. I think, and that would sort of make it broader without really going into should children be detained and where are they detained and those things, because the countries who do have child justice systems would not want those sort of provisions in the model law, and then you'll start having problems. But I think there could be a way in which one can slightly broaden places of detention, and I think it would be important, because we know that there are some facilities where judges send people to a mental institution, they can stay there for 20 years and no one ever goes to check on them. So that's, people can really say, I think, if you feel this is important and we should actually broaden it, but we can't go all over. So it just, okay, so Lucas wants to tone me down and say that's not what we agreed, and then Doreen after him.
No, I don't want to restrict you. I just want to make a point about the flip side, is that we've come across over the years of people being detained in police cells where they should in fact be detained in a prison. But because there isn't a prison in that area, or the prison is completely overfull, it's a stopgap measure to detain the person in a police holding facility. And that's not desirable either. We don't want that, because for a variety, police cells are not there to detain prison people longer than 48 hours. So we must just be careful of that as well.
Yes, Doreen?
I'm just wondering then, I mean, because there's the consultation happening on Friday, right, with the judges and NHRIs. And in most instances, the national human rights institutions have an overarching jurisdiction. And I'm wondering if then, with the recommendation that was made just now about making reference to other relevant laws or legislation, then that's something that can be worked into what we do with the NHRIs, because then they have the jurisdiction to do oversight across the various institutions. So this can remain a prisons model, but have an acknowledgement that sometimes imprisonment happens outside of a literal carceral facility.
That's a good point, because all NHRIs provide for visits to, and they tend to say places of detention. So they are broader and they exist in all our countries. And what we can then do when we look at the National Human Rights Institutions section, perhaps there to just to make a reference to other potential places of detention. At the back, you had your hand up?
Yes, I think in thinking about this, dealing with children's issues would require like a lot of specialized input, and this may not be the most appropriate kind of policy to do so. But because the section has like 4 points and it really encourages like an expert coming in, so maybe to specify that these are considerations in relation to children who are in the care of a prisoner or under the guardianship of a prisoner, so that at least it has that limitation. So we understand that an expert is coming in to see if the living conditions are appropriate for the well-being and safety of the child who is under their mother's care or under a parental care.
Excellent. Anyone else on children? Oh, we're doing so well. Yes, interesting one. Foreign nationals. Now, at the technical working group, there was a big debate about whether foreign nationals is a nice word to use. And people suggested you should say non-citizens. I personally feel if you call anyone a non-something, it's not very nice either. But acknowledging that not everyone's a foreign national, some people might be stateless persons. In some countries' legislation, they say foreign immigrants, they say aliens, they say prison acts are really horrible with the way in which they define things. I don't know if this is the lesser of all evils, or if you can think of a lesser evil than foreign nationals as a terminology. That would be the one thing, the actual word. So what it basically suggests is that when any oversight body goes to a correctional center and they come across foreign nationals, they have to determine why they are there. Are they there under immigration laws, or are they there under, in terms of the criminal justice system? If they're there in terms of the criminal justice system, they should be treated in the same way as all other nationals. If they are there under immigration rules, there are really other issues in terms of how long their detention is, so that they don't end up staying indefinitely, with whether the detention is even compliant with the law, and whether they have access to consular services and other rights that they might have on the basis of being so detained. I mean, Victor can speak to this, but you often come across prisoners, people in prison who are there simply because they couldn't prove they were foreign nationals basically without a valid visa, and then they just kept there indefinitely until one day the government has money to deport them. And that often, and this is one of the ways in which children often ends up in prisons under the immigration laws themselves. So, did you want to say something, Victor? Yes. Yeah.
I think what you are saying is true. There are two different categories. There are some foreigners who have committed crimes. Let's say they have committed robbery, those are taken to prison. But the problem in Malawi, we don't have a detention center like Rindera. So apparently each and every foreigner is taken to prison. And now these are the people who are actually in Malawi because they don't have valid papers, or maybe the papers have expired, or maybe they are working without work permit, so they are taken to prisons. The unfortunate part is that they can stay in prison forever. When the prison department, my friend here, they try to push, most of the time the police say that they are not in our hands, they are in the hands of immigration. And it appears immigration have got a special law, they can just detain people and then they go. So a number of human rights violations that have been occurring, that have been happening in our custody. Until this other time, together with Southern Africa Education Center, we challenged the government in one of the Northern Region prison. That's where many immigrants are. You know, what happens is that the prison is meant to keep like 300 plus prisoners. That's the capacity, but we found that there are 700 plus. So a good number of them, more than half the population of that prison, they are the foreigners. So when we went to court, the court agreed with us that no, indeed, I think it's taking a lot of time, a long time for these people to be attended to. So they gave the government that at least the 30 days should be the minimum. Otherwise, the maximum, huh? Maximum, yeah, so should be the maximum. Otherwise, at least now, there's a sigh of relief, but still more. You know, our system, if they are used to that, there's still more arrest people using the same provisions. And the funny thing is that most of the foreigners, they don't want to come to Malawi. They just want to pass and go maybe to Mozambique or to go to South Africa. But we get the burden of feeding them, and then the government takes them forever. So that's the situation that we are having. So it's quite different from some of you.
Thanks, Vic. Yvonne?
The content of what we want to achieve with that provision seems slightly problematic.
Let's not switch off.
So, while I think the content suggests that the focus is really on aspects of immigration, that title may be a little bit of a misnomer, and it is likely to ignite some debate about differential treatment. So I'll be careful in the language that I use to deal with this particular aspect. I think the immigration question is important. The aspects of statelessness, and it doesn't even come out. The statelessness question is much more important even than the immigration question. So I think we may have to reword the principle that we want to address in this particular portion.
Thank you. Yeah, there was a lot of debate at the technical working group also about how we actually, what we include in this section, and for example, the specific issues around stateless persons. So for example, if there is someone in your facility who is a stateless person, there ought to be an obligation on the prison facilities to actually assist them to get the right documentation or to regularize their status or some sort of thing, because otherwise it means that they'll be deported nowhere and they'll just stay in prison because there's just no other remedy available. So there's a lot of issues there. Let's just look specifically at oversight. What do one need in relation to oversight? And here the point really was, one, you can't just go to a facility to do oversight in relation to prison conditions and those things without also knowing immigration law. In case you go there and you find people are detained there under immigration laws. The second point is that when you go there, you must be able to speak to people, so there ought to be interpretation services, but one must be very careful of using the facility's own interpretation services, because anyone at the facility is always going to interpret things. Well, not always. There might be, it's just advisable to use independent interpretation. The other thing is the statistics part. And this is what Victor mentioned. People get lost in the system. So as an oversight body, if you go there and you see this place, half the people are foreign nationals kept under immigration laws, that's an issue. That's an issue that should be raised with Parliament. It should be raised with the Department of Home Affairs or whoever deals with immigration, because it's clearly showing that people are being incarcerated under immigration laws, and that suggests that there's a different problem that ought to be attended to. The other point was that certain people who are detained actually do have other rights under international law and ought to at least have been informed of those rights. And this is something an oversight body might want to look at. And then there's the issue, and this happens sadly. Xenophobia means that if you're a foreign national and you get into a prison, you will be treated worse. You know, like it's, in our region, that is what happens. So foreign nationals are, by virtue of being a foreign national and by virtue of the xenophobia within our countries, they're vulnerable populations. And when an oversight body goes to a facility, they need to ask about that, to see whether there are actually equal services provided to people. And then the other issues was about rights and those sort of things. Are they, now, there's an interesting issue that arises here, and this will, it will come up everywhere, but I think, and I don't know if there's people in the room who might have experience in relation to this, but if you're a foreign national coming, say you're passing through Malawi, you're on antiretroviral treatment, you're in immigration detention, what's the continuity of care there? And to what extent are you being offered that continuity of care in the same way that other prisoners might be offered that? If it's not an issue, it's not an issue, but it might be an issue, so I'm flagging it. Did you want to say something, Victor?
And the way the way the prisoners in Malawi they are kept is like The remanded prisoners, they are under the Malawi Police Service, which means that if they get sick in the hospital, these guys, they just refer them to the police station where those people were arrested. It's different from our colleagues in Zambia. We are trying to follow your model. So now it becomes difficult when it's a foreigner. It means that it's immigration department who are supposed to take care of that foreigner. And you won't find them anywhere. They are not used to take people to hospital, to stay with them to hospital. Then it means that that foreigner is going to be languishing in jail. He's sick and he's going to be languishing in jail. So that's why I think the vulnerability suits for the foreign nationals.
Who wanted to add first? There was a...
You want to add?
Harrison. Yes, Harrison, you can go. Then there was a hand there, there was a hand there. Okay.
Just to add up what Victor said, we meet a lot of challenges. For example, when we have some foreigners, we have a burden on languages. At the same time, some of these foreigners, they run away from their original homes just due to war. So they have gone through different countries, and some of them they brought in our prison tuberculosis, because they have gone, and there are many. They have been put in trucks, so they bring inside some of the TB and cases. So our fellow officers like immigration and the police, when they get sick, these remandee inmates, you refer them to central hospitals via immigration or police. But these officers, they are afraid of looking after them at the hospital. So they just pick them and put in their cells. After some time, they bring them back. So this is some of the challenges. We have been in talks with our fellow department, so that maybe, if it's possible, they could maybe have some health personnel in their institution. Yeah, that's all.
Thanks, Harrison. Can I ask, while we're at it, has the department dealing with immigration ever sent people to come do prison inspections at the places where they're holding those prisoners? Like, do they come, where they're holding the foreign nationals, do they come check up on them?
No, unless maybe if we push them. Sometimes we push them, we go to their offices, or sometimes the officer in charge can call them that, I think, if you're not coming, we can release your people. So you find that they are coming, but to them, it's a dumping ground. We have put them, and that's the end of it. Yeah. So now the burden becomes back to Malawi Prison Service. Yeah.
Okay, so just on that, I think it's important, Victor and Harrison, that you perhaps think about how do we strengthen this provision in relation to continuity of care and in relation to people not being just dumped there. So I have a hand there, and then back here to Yvonne. Yes.
Thank you. Listening to everyone's comment here, I think the issue of prisoners, actually it's a very serious issue. Even when I was PS Justice, it was always landing in the Ministry of Justice, the issue of thing. So what the model law needs to do is to have a specific provision on select committee oversight, parliamentary select oversight. Don't leave it to the ordinary oversight institutions, but Parliament itself must enter prisons under their thing to hold accountable the executive in relation to foreign prisoners. Because it's never attended to, and I think all of us here can't pretend. It's not only happening in Malawi, it's happening in Zambia, it's happening in so many countries. And we should, in that provision, actually lay out guidelines as to the action that needs to be taken by the select committee and the referenced laws for immediate release, be it the Exchange of Prisoners Act, Convicted Prisoners Act, and the Mutual Legal Assistance Act. All these need to come to play now in ensuring early release of the foreign prisoners. Because I know that is where the problem is. Prisoners have been known to be in cells, foreign prisoners, for over 30 years. We've come across those things. He has become an old man, or she has become an old woman in prison because there's no one there to take responsibility. The immigration department, once they dump them there, that's it, they can even kiss them goodnight. So let us put that burden on parliamentary oversight. I think that is very important, and the law should be specific.
So if you can just take note of that for us too, when we look at mandatory reporting, to include additional provisions to make sure that Parliament always knows how many people, foreign nationals, are being detained. There is a whole section on parliamentary oversight. The difficulty we had with that section is that it's being very specific about the portfolio committee oversight because different governments have different types of, different portfolio committees, but it would be really useful for people, we'll talk about that tomorrow, but to start thinking about how do we add the portfolio committee oversight better into, a lot of this parliamentary oversight section is borrowed from the GBME model law and other places, but it would actually, we should think specifically how we strengthen it and how we strengthen that multi-parliamentary, multi-departmental issues as well within the oversight system. Brilliant point. Comment there?
And then another issue, just before I leave the mic, it's on the persons persons with disability. If you look at most laws that are based on the convention, all right, the UN convention, you'll find that there are imperatives in there, which are the checklist for such persons who are incarcerated. So those are the ones which you can borrow and put in the model law for oversight. Yes. That's the only way you can do it. Otherwise, you can't legislate for it because it's legislated. But what you are targeting is the oversight mechanism to ensure the law is operationalized the way it was intentioned to be. That's what we are looking at. Yeah.
So the idea with that was that we actually add, in addition to the model law, annexures specifically, which would have those tools around and checklists around specific areas. Mozambique?
Muito obrigada. Eu gostava só de partilhar uma realidade diferente do que os outros países têm relativamente ao tratamento do recluso. Ao tratamento do estrangeiro. Nós, em Moçambique, não temos uma distinção relativamente ao tratamento. Tanto o recluso estrangeiro quanto o nacional, relativamente à saúde, têm os mesmos direitos. Quando o recluso não tem, o estrangeiro, quando o estrangeiro não tem a documentação, nós procuramos saber do que país é. E contactamos o Ministério dos Negócios Estrangeiros e, através do Ministério dos Negócios Estrangeiros, entram em contato com a embaixada deste país, no sentido de poderem legalizar a documentação do recluso. Se ele fica doente, ele tem o mesmo tratamento que os outros. Nós fazemos o rastreio ou observação à entrada de todos os reclusos, incluindo o estrangeiro. Se ele é doente, tem a fazer o tratamento antirretroviral, nós logo providenciamos o tratamento. Nós deixamos que ele, não deixamos a parte, como percebi de Malau, que fica doente, fica na cela até que a imigração tome conta. Então, eu acho que, relativamente à saúde, nós tínhamos que ser humanos. Não deveríamos fazer uma distinção entre o nacional e o estrangeiro, porque o direito à saúde é um direito fundamental para cada um de nós. Eu acho que nós tínhamos que rever esta parte do tratamento do estrangeiro, independente da pessoa ser estrangeira ou não, ele está doente, ele tem direito à assistência médica. Obrigada.
So thank you. Just on that, so you'll see point 5 here, we said that you have to ensure that there's equal access to rights and services. Is that sufficient? Or do I need to elaborate, or do we assume it's all there, it's all fine? The reason I'm asking is that legally prisons have a duty of care. So even if someone was detained, so legally, even if someone was detained, you would still have to provide them with health services, even if they might not be able to access those health services once they're outside of the prison. The reason I say that is in some of our countries, prisoners are being refused, foreign nationals are being refused access to health services within the public health system. But even if that is the case, once they're within a prison, there's a duty of care that changes that sort of legal obligation. And is there a need for us to spell that out? Because we're picking up on the issues there. So I've got Yvonne and then Zinanani.
It's really the principle for me, and I agree with my sister from Mozambique. You know, I'm wondering whether we are not creating, maybe even in a nuanced form, that there's going to be special treatment. Because inmates in correctional facilities inherently are vulnerable, all of them across the board. And the moment we lift out one, I can understand vulnerable groups such as persons with disabilities and so on, but I'm imagining that I worry a little bit about the tension that specifying or identifying, persons that are considered foreign nationals or those that are subject to immigration practices or laws are receiving special treatment. So I don't know how we can deal with just putting a principle rather than very specific aspects of it. I'm a little bit concerned about the tension there.
So it's very funny because it depends on who you ask, because I had the same thing about, because you can never have an exhaustive list, right? So should we rather just have a provision on vulnerable groups and have people then define it? But once you speak to people who work with foreign nationals in prisons, they would have a different perspective of and that's each of these vulnerable groups, you'll see that people have different perspectives depending on whether it's one of their focus areas or depending on whether it's not. But I have a feeling that for the model law to pass through the parliamentary forum, we might end up having to have just a vulnerable groups conglomerate thing. But for the moment, probably as part of the consultations, it's useful for us to just identify if there are specific issues, because that can always be taken out and put in the annexure at the back or something. So we're flagging it, so it's important to raise the specific issues that people face, but then it might not end up in the model law, but it might end up at the back of it or something. Zinenani.
Yeah, mine was, I was interested on what my colleague is saying, I forgot the country, about the ombudsman. I think it's different how they work our ombudsman in Malawi, because we know that ombudsman, they just work in hospitals, in government hospitals, and they are not active as other countries. So I wanted to learn and understand what's your structures do you use to make ombudsman active and work in prisons, have power to work in prisons? And I was expecting that as SADC, we should work as uniform about the ombudsman as way forward. I'm just thinking. Thank you all.
There is a meeting later this week specifically dealing with the ombuds people. So we are going to deal with that in a little bit more detail later this week. The back there.
Ok. Eu realmente fiquei interessado com a intervenção da minha colega de Moçambique, porque em Angola a realidade é similar. Não existe um tratamento discriminatório entre o estrangeiro e o nacional. O que me parece é que a lei modelo não tem que trazer uma perspectiva discriminatória, essa discriminação legal. O facto, por exemplo, de haver uma disposição que diz considerações sobre supervisão em relação a cidadão estrangeiro ou apátrida, me parece que aqui é uma discriminação legal. O que pode acontecer é que uma lei modelo tem que garantir os mesmos pressupostos que normalmente são integrados dentro da criação da lei. Uma lei tem que ser geral e abstrata. Aqui trata-se do cidadão recluso, quer ele seja estrangeiro ou nacional. Então, parece que nem temos que levar essa proposta, a proposta, a forma como está construída, não devemos levar aos parlamentares já nessa perspectiva da discriminação. Temos que apresentar aos parlamentares o ideal dos direitos humanos. Se tivermos a falar dos direitos humanos, a discriminação legal, ela não é aceita. Então, podia estar simplesmente em relação ao cidadão prisioneiro, quer ele seja estrangeiro, nacional ou apátrida. Okay.
I mean, just on that, you might think they're not being discriminated against, but they are, because people who are in a prison that's designated as the immigration facility gets different treatment from other prisoners. It's how it is. So there is a need for oversight, but whether we frame it within this, or whether, like with a heading that says foreign nationals, or whether we tweak it into something else, that's really where I think it comes into the strategy issues. There were first they, then Harrison, then Lucas. Yes.
Yeah, I totally agree. I agree with both the speakers, but what I want to emphasize is that the discrimination clause will come in the general human rights part, where you are putting out your principles, your blah, 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 blah. It won't fall under the specific categories of prisoners. I don't think it should, because it will be, as they rightly say, discrimination within discrimination and allowing it. Basically, no. So I agree with what they're saying. It's the way and where you put it. These provisions, what I'm trying to say is to target issues of early deportation, early release, and the mechanisms which must be followed in accordance with the international standards, where you have foreign nationals in your prisons. And they are very specific and they're well known. So all we have to do is to borrow from some of these conventions and put them in our model law. That's all. And the draftsmen, while doing national laws, will know how to amplify those provisions to be in conformity.
Very useful. Harrison?
Let me come again and make a correction. Maybe, I think maybe some they didn't get me well, if I'm correct. As Malawi, we said when we have received a Mandi or an immigrant, it means is under, of course, they bring them to prison, but it's under Malawi police or immigration. On the medical treatment, when these people get suffered as head medical officer at the prison, we do treat them, everyone equally. But it may happen that your facility, you don't have enough materials. You need this one to receive a further treatment to other big facilities. For example, as Blantyre clinic, you don't have some other equipment, but maybe you have seen that the client might benefit from other investigation, probably at Queens. He's a Mandi, at the same time he's an immigrant. Since I've already said that this one is being represented by a police or immigration, you need to make aware of the immigration department or police to take him to hospital as a referral, not that we don't treat them. We treat them, but if there is, you have thought of that, you might need further management. For example, scanning X-ray, of which as prison we don't have that. Sure. At the same time, I don't think. Let me come in with this idea. If it is impossible, is it possible for SADC region prisons, if they have some inmates that are foreigners, if it's possible to maybe refer them to their original countries? For example, Malawi and Zambia, they work together. If there is a Zambian inmates, they are in Malawi, maybe they've been sentenced for maybe 10 years, 5 years. They've been convicted there. We do exchange. So is it possible here as a SADC region to
yes, absolutely.
To take this? Maybe I'm in Mozambique, I've been arrested there, but I don't have a relative there. Can there be any alternative that Malawi and Zambia and Mozambique, they can exchange inmates? So that maybe I myself, I should be visited by my relative from my own home.
So
is it possible?
There's actually a SADC, I don't know if it's a convention or what it really is, that speaks specifically about the transfer of convicted offenders. And that law exists. So yes, you can transfer offenders within the prison system, but only after they've been convicted or when you've deported them. And that's where the problem comes in, what happens in the meantime and who's looking after them. Lucas, you wanted to come. Oh, thank you for withdrawing your comment. We need to move on. If you don't, are we still on foreign nationals? Last comment on foreign nationals at the back there.
Yeah, I just wanted to comment on the transfer of convicted foreign nationals between countries. It is a tricky one. I think, yes, SADC has got some kind of protocol that controls that. Again, there needs to be an agreement between the two states to agree on that. Thirdly, I think there need to be some kind of harmonization of the laws, domestic laws, so that that can happen in a smooth manner. If I were to make an example of the Republic of South Africa and the Kingdom of Lesotho, there has been a serious challenge. There are 2,260 Basotho in South African correctional institutions. And that is almost exactly the same number of inmates we have in Lesotho. This morning we have 2,400 inmates in Lesotho. So what South Africa has been pushing for is for them to transfer all the Basotho inmates to go and serve their sentences in Lesotho. And Lesotho has been resisting because that is going to double the number of inmates we have in the country. So I think it is an important issue, but it needs to be handled well. The two countries have to agree, look at the modalities, and again, follow what the protocol is saying. Pregnant women, nursing mothers, and other vulnerable groups, not every inmate, but there has to be some kind of an agreement between the two states. Thank you.
Thank you very much. Oh, Mauritius. Okay, last comment.
I'll be very quick.
Well,
Because in my country, the burden of prisoners for foreign is 64%.
Use them.
I'm sorry. So in my country, the burden of foreign prisoners over the total is 64%. Because Mauritius is in between. Very often, commitants will land here and then pass to other countries. So they're caught in our island. I would suggest, in line with Dr. from Malawi, if we, along with the SADC Convention of interchange of foreign prisoners, that if we could fast track the cases, recommend a fast track of cases, especially for, like Sir just said, vulnerable groups like pregnant women. In Mauritius, our public health is free, of course. So many people come here to just deliver. They hide their pregnancies and travel. So they come here and stay with us forever, along with the kids. So fast track the cases, have a different code, like family code, just for those foreign cases. That's all.
Thank you. I like it when people come with very clear proposals. Let's move on to persons living with HIV. Now, if I read this section, it's almost clear that we don't need this section. Now, you could decide to, if our tech person can just look at the screen, there's some glitching happening. First,
desculpas.
Thank you.
Posso desculpas?
Uhum.
Eu tinha comentário a fazer.
Yes.
Primeiro, para concordar aqui com o meu colega em relação à troca de prisioneiros, seria uma questão muito complexa, muito delicada, e que de facto devíamos ver em relação às legislações internas de cada país, de modo a não criarmos antinomias, né, ou desarmonização. Mas há uma questão mais importante que devíamos ver também em relação à Convenção dos Refugiados, penso que de 1951, que também proíbe para, nos casos de refugiados, o princípio de não retorno, porque existe algumas comunidades africanas em que existe o conflito étnico, que as pessoas sentem-se bem num outro país e desejavam, mesmo que estivessem doentes, não voltar para o seu próprio país, porque provavelmente a situação não seria muito boa, né? Existe isso. E eu gostava de propor que a discussão em relação ao direito à saúde para o recluso fosse um pouco mais profunda em relação ao facto de nós fazermos essa discriminação de estrangeiro, porque além dos conflitos étnicos que existem no interior de cada país, o facto da pessoa ser recluso gera a questão da discriminação e o estigma. O que eu devia propor é que existem muitos países que o estabelecimento não tem um estabelecimento hospitalar dentro dos centros prisionais. E um recluso doente é obrigado a ser transferido num hospital público, por exemplo. Podíamos desincentivar a ideia de que um recluso, estando num hospital público fora do estabelecimento prisional, não tivesse sido identificado com a vestimenta dos serviços prisionais. Porque várias vezes o que acontece é que ele está doente e precisa da assistência médica fora do estabelecimento prisional, numa clínica ou num hospital público, mas a regra dos serviços prisionais é que eles, mesmo ainda assim, estejam vestidos com uniforme de prisioneiro. Só que aquele uniforme pode levantar uma ideia de estigma em relação à forma como ele vai ser visto e a forma como ele vai ser tratado. O que nós temos que fazer é que as pessoas, independentemente da sua condição, elas devem ser tratadas simplesmente como pessoas. Não tratar uma pessoa como um recluso, porque o direito à saúde não é um direito que precisa ser conservado de forma absoluta. O facto dele ser restringir a sua liberdade, essa restrição não afeta o direito à saúde. Se um indivíduo é tratado num hospital público, mas é obrigado a colocar um uniforme como preso, como aquele que violou, por exemplo, há muitas pessoas que terão passado pelaquela situação, sendo enfermeira ou médica, poderão ter um tratamento de estigma. É o mesmo que acontece várias vezes com cidadãos que violaram determinadas crianças e são submetidos a um julgamento, e às vezes o estigma vem mesmo pelo juiz que está a julgar, porque o juiz que está a julgar ou a juíza terá passado uma situação igual. Então penso que temos que também criar aqui uma questão de uma reflexão profunda em relação à efetivação do direito à saúde nessa dimensão.
Okay, that's tricky. I think a big part of your recommendation goes to the section we will deal with around monitoring whether health professionals who work with prisoners have received the right training. And I think that section probably only does, and when we look at the health professional section, to make sure it includes health professionals both inside prisons and those to whom prisoners are referred to. Because your issue is about stigma and discrimination, but there might be security issues if you don't put them in a uniform, and there might be other issues coming up. But I think the underlying issue is the stigma and discrimination against different types of vulnerable groups, not just those ones. And then the question is, how have people been trained to actually deal with those forms of to not discriminate against particular groups? Because I think that same discrimination issues comes up in all the vulnerable groups, and you can add more vulnerable groups like ethnic group, minorities, and whatever else also, which then almost brings one back to the point about just have a non-discrimination clause and a more overarching provision. I'm going to move on to HIV. There was a debate about whether the section should say HIV or whether it should say communicable diseases or whatever it should say. I don't think HIV is as big a problem as TB is, for example, in our prisons. So should we have a section on TB or should we not have a section at all? That said, we were trying to look at what already exists, and there is an existing minimum standards for HIV, TB, and hepatitis and STIs in prisons in SADC. So that exists. It's merely about saying we must monitor that it's being implemented, although that document itself is a bit dated. And then there's just oversight mechanisms must make sure that there's all the basic necessities. I almost feel you don't need this section. What do other people think? Or should one just have like general health there or something? People with illness, I don't know. Do we even need this? Okay, debate it, ponder it, Lucas.
I don't know, maybe the health professionals in the audience can advise us, but I mean, there are a number of illnesses and health conditions that are not absolutely unique to prisons, but they're definitely common in prisons. And maybe that's a way to insert that into a monitoring instrument. And I think TB and hepatitis are common, but so are scabies. So maybe a prison-specific health focus in your oversight instrument would be helpful. Thank you.
There was a comment there, right? You had one first, and then it's you, and then it's you.
I was going to agree with him that really some of these things you don't have to have individualized clauses for them.
Yeah.
If in the beginning, when you're dealing with the human rights issues, you can just generalize on some of these issues, the right to health care, blah, 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 psychotherapy care, all those things. The way we normally put it in most conventions, I think we should be safe because, as I said, it's this model law doesn't end here. It will end on the National Legislative Drafters desk. And that's the person who's going to amplify it into operational provisions. So we shouldn't overdo it in the model law. I think we are overreaching. That's what I was saying earlier on in the morning. Let's try to temper it down a bit.
That's the problem if you're consultants or civil society. Overreaching is what we love doing. Yes.
Thank you. So I do think that in terms of HIV, the bone of contention here would be that I don't know about other settings, but in my country, HIV prevention is not available for prisoners because the assumption is that, they're not supposed to be having any business doing anything that predisposes them to HIV, while in actual fact, that is where most of them do contract HIV. So things like availability of tools for prevention, condoms, lubricants, and things like that are not available in prisons, and that is why we continue to advocate for access to HIV services for prisoners in prisons and closed settings. For the same reason that we started off this conversation in the morning to say that prisoners' health is public health. So are we saying that while they're outside prison, we can help them prevent HIV, and then they go into prison, they contract HIV, and then when they come out, now they are HIV positive and they have to go back into the community. So for me, that conversation and it being specific for HIV relates to that. But with all the other diseases, I don't think there's any issue in terms of access. If they go there and they're screened for TB, they will get treatment. But if they go into prison and they are saying they need pre-exposure prophylaxis for HIV prevention, they're not going to get it. Thank you.
Thank you very much. There was a comment from Mozambique first.
Sim, muito obrigada. Gostava mesmo era de concordar com a colega que disse que relativamente a este ponto podemos deixar direito aos cuidados de saúde, mas dizer que para o HIV nós tínhamos que também incluir a distribuição de insumos de prevenção. É verdade que nós, a nossa cultura, digo nós como africanos, ainda temos o pensamento de que as relações sexuais entre homens não existem. E, na verdade, eu costumo dizer que estamos a tapar o sol com a peneira, porque isto está a acontecer. E eu posso dizer isso na base do último inquérito que nós fizemos em Moçambique, na população prisional e nos guardas penitenciários. Em 2013, a nossa prevalência para o HIV, ao nível dos estabelecimentos penitenciários, era de 24%. Hoje, nós estamos com 25,3% para os homens e 31% para as mulheres. Isso quer dizer que cada ano que passa, nós estamos a aumentar aquilo que é a nossa prevalência. Na base disso, o que é que o setor de saúde penitenciário e o Serviço Nacional de Saúde fez? Sentamos, analisamos aquilo que é o inquérito e acabamos chegando à conclusão que nós temos que advocar no sentido de haver distribuição de insumos nos estabelecimentos. Neste momento, nós estamos a finalizar o guião orientador para todos os estabelecimentos penitenciários para a distribuição de insumos, que é um guião que, ao nível, é um guião que nós estamos a elaborar em coordenação com o Conselho Nacional de Combate ao SIDA, e queremos que, ao nível mais alto do país, este guião seja lançado, no sentido para eles poderem perceber que, na verdade, esta é uma realidade dentro dos estabelecimentos. Relativamente à tuberculose, sim, eu concordo que nós temos que fazer a testagem, mas aqui há um problema sério que tem a ver com a superlotação. Nós podemos estar a testar a rastrear a tuberculose, podemos estar a tratar, mas se eu rastreio e continuo a colocar aquela pessoa com tuberculose no mesmo ambiente que os outros, praticamente não estou a fazer nada. O que eu quero com isto dizer? Há uma necessidade, e eu percebi logo no início que nós temos estabelecimentos antigos, infraestruturas degradadas, de construção do colono. Há uma necessidade de que os governos poderem fazer novas construções, mas sempre terem em conta a parte da transmissão da tuberculose. Nós estamos com uma superlotação. Se nós não conseguimos superar a superlotação, também não vamos conseguir terminar com a tuberculose. Obrigada.
Brilliant. So, what I'm hearing from you then, this is an important point. I note 3 hands. It's there at the back, then Humphrey, then Kitty, is that there was a time when we were doing well with HIV, and now things are backsliding again, and prevalence rates are increasing and all those sort of things, and it actually makes sense to continue to have that emphasis on HIV, TB, and other STIs and those sort of things, and not to lose the momentum that we had, but rather to keep it in. Let's go at the back and then we move this way. Yes.
Thank you once again. I think since the Southern African region or sub-region still remains the epicenter of HIV in the whole world. When you look at the statistics, in my country, 31.4% of the inmates are HIV positive, male inmates, and 69% is among female inmates. That's a very high prevalence rate. So I think as a sub-region, we should not shy away from talking about HIV. It is still an issue that needs to be dealt with, particularly in correctional institutions. So I do not disagree with people who say we should try to generalize, but let us be careful not to shy away from mentioning HIV in our model law. Thank you so much.
Thank you. Humphrey?
Thanks, colleagues, and thanks, Anik. I think one of the things that we've been struggling with in a lot of the PLHIV programs, TB, STIs, has been the quality of the data, particularly as it relates to other marginalized communities. So your key population data when it comes to HIV is bad. You will not even get it from any of the prisons. So in the remaining part, if we can make an effort to ensure that we work on making data make sense for marginalized communities. Otherwise, if you don't have the data, it means the problem is not there. And therefore, there will never be any resources that goes to those populations. And then the other thing is that, a lot of what we are seeing now for sustainability, it has to be funded by our own governments. So the data has to come from us, from within from within our own government facilities, defended by our own parliaments, and funded by our own people. So the challenge is that we've had these programs that have been coming, supported by Global Fund, supported by PEPFAR. We don't have them anymore. So it means that if you have a bit of programming that is left within the prison population, it is a program that possibly is underfunded. So it is very important that we really settle back into how best do we fund these programs. And stigma and discrimination hasn't changed. Unfortunately for marginalized communities in prisons, it becomes a multiple layer. You are most likely to die having been to prison as a gay man or as a transgender person, as a sex worker than any other general member of the population. And you are most likely to even struggle the more even upon discharge for integration. So I think enunciating this language and emphasizing it where we are with the response, because people are tired. We have been talking about HIV. No one wants to hear anything unless it's new. So I think this is something that we really need to go back and speak to.
Thank you. We'll make it sound more exciting if people don't want to hear about it. I've got Kitty and then Boemo.
Yeah, and I mean, look, it's been interesting to hear people still arguing for differentiating and particularly pulling out and protecting the rights of people living with HIV and TB in prisons. I wanted to actually go back to something Humphrey said earlier, also talking about HIV prevention, which I see you have noted there. And I think it's going to be interesting to see if those guidelines need to be updated, if we're going to try to make sure that access to pre-exposure prophylaxis is available to prisoners. If you did want to refer to something more updated, I mean, the SADC regional strategy on HIV and SRHR for key populations, I don't know, I mean, Boema, you have to advise what the status is of the strategy compared to minimum standards, and I'm not entirely sure. But it is more updated as 2024 to 2030, and it does refer to prisoners. But it's very quite short.
I know the part about prisons is a bit iffy.
Yeah.
But but I think it's important to like emphasize it as a more recent standard. Boemo.
One of the things that we should take advantage of is to restate already agreed to instruments. Whether or not it's outdated or whatever, but we must amplify that because it reminds members where you get the consensus from, if at all. When you look at the minimum standards for the protection of the sexual and reproductive health of key populations in the SADC region, that is the title of the minimum standards, the agreement was very difficult. However, when it came to prevention and ensuring that we contain and able to, they were unanimous on that. So I think it's very important for us to go back and be able to cross-reference these so that it doesn't appear as if we are starting all over again from what has been agreed to. And before you state that, I think we should also go back to the definitions that were already agreed to. I know they have progressed, but I think it's also very progressive. For instance, when you look at, I know the issue of key populations has been dropped as we went further with the gender-based GBV model law. They wanted to settle for vulnerable groups, and they said, please don't define them for us. Each of our countries have defined those, we know who they are, so don't give us. However, when you go to the minimum standards, they've defined key populations, and it's very clear: men who have sex with men, people in prisons, people who use drugs, etc., etc. So I think let us leverage on an already agreed language and documents where possible, and that way they are bound by, at least for approval purposes, what they've already agreed to.
Thank you. Okay, so Yvonne and then...
Although I wanted, I don't think we're yet there, but I wanted to find out, because I'm reminded by Ntate Lesotho, you recall when we're dealing with this issue, the consensus that we arrived at when Lesotho had progressed was we'll look the other way, but we're not changing the law. Lesotho can lead us, but we are looking the other way. And they can throw them there. They can throw the loops and condoms in prison. We won't say anything, but we are not changing the law. I wanted to ask, as we get to that section, what is the current attitude in your prisons? And should we be bold and put the facts guided by evidence, or do you have any other guidance? Not for now, but for later when we get to that section. I just felt I must throw it in there.
I'm almost just linked to that poem. I almost thought when HIV prevention might actually be easier if we framed it more broadly, because Humphrey earlier was speaking about people taking prophylaxis before they go into prison and the continuity of care and those sort of things. So that's almost a slightly easier argument to make than the condoms in prisons argument. I'm just putting it out there whether one wants to remain broad. And this is something we also need to consider, because listen, we can make the most beautiful thing here because it will be watered down anyway. So do you start, should we water it down, and should we leave it to other people to water down? So just keep that in mind about what would be your ideal way of oversight also. And then we can later on decide, or people can decide for us how much it gets watered down.
But
Yvonne,
sorry,
yeah.
the question is, what is the evidence pointing us to? We shouldn't forget the principles that underpin the development of model laws. That is driven by evidence and not consensus, blah, blah, blah. So I agree with you, but I'm also saying, is there any way where we highlight the prevailing risks in relation to certain populations that we can be able to say, at least the following seems to be where we are stuck?
I think we need to improve the section in the position paper on that. I think the evidence exists. I don't think, Lucas, we went into enough detail in the position paper on that. So, okay, your job is there. It's first Yvonne and then you. Yeah.
I'm not sure whether I understand the question around evidence, but what I know is in a country such as Namibia, where in recent times questions around sodomy, and I know that there is a section on the LGBTQI community, is that once you have, sometimes for some jurisdictions, and I know of my own, once you see certain language in even a model law, sometimes that could be the only reason that it gets completely disregarded. I don't know what the court's decision would be in the Supreme Court around sodomy law, but I know, for example, the Commissioner of Prisons made it categorically clear we cannot, for example, deal with issues of condom distribution and so forth in violation of an existing piece of legislation. So I think I would be very careful if I were you to, and this is also the question about when you list, do you list everything? And when you exclude, then you're also asking others to then say, how about this, how about that group, and so forth. So I would really like us to maybe try and see whether we can stick with vulnerable groups. While I don't take away from what my brother from Lesotho was saying around questions of HIV, because there's also the distinction between prevention, which is you don't want people to get it while they're in there, but those that get in there with it, I'm sure they continue to get some kind of support and treatment. But those would be your challenging spaces. I can tell you, any legislation that suggests that condoms must be distributed in prisons in Namibia would be rejected, and anything that has even remotely a whiff of LGBTQI would not get any support.
I support my sister here because for sure, if we will say we need to provide condoms, it's like a knife with double-sided. We will have to admit that we are for something like allowing sodomy or other things. So it's very angulated. But how we can sell this product is the economic cost. And the evidence is always when the prisoner came in, screening. So I would like to have the HIV prevention under three headings. Any disease prevention has been like this: screening, education, and prevention. HIV prevention is very well established by WHO, condoms, etc. We don't need to go in depth in that. But the screening is like each, sorry. Yeah, so each admission do a screening. I think this is how it is done in most prisons. But once you're negative, the person is like that. So unless that person is sick or have some symptoms, or like will get out, will do some screening, then he will be caught as HIV. So we need to show the government that, we need to do regular screening, because rapid tests are not that expensive nowadays. At least every 6 months, 0, 6, 12, it goes on like this, just screening. So when that person will be caught positive, so it will create awareness that there's something ongoing. So it's data, it's facts. The moment you catch one, they will be referred to the AIDS physician. So we have the health professional which will back up. Then we can put forward the use of condom in prison. But unless we have those evidence, we cannot go upfront that we will do this and that. And then I just got to know what Malawi friends are doing is they're educating the prisoners in themselves. There's like 5, 10 prisoners are educated in health matters. So they are the one who will bring up, that person had this issue to the doctor. Because not everyone is educated, has that level of education in prison. They're very low socioeconomic, never went to school and everything. So education of the prisoners will be a liaison health prisoner between the doctor and the sick prisoner.
Thanks, and again, and thanks, colleagues. And I think it's very important what colleague is asking, that how do we reframe and sell the conversation around reintroducing some of the prevention modalities. Very important to say that there are novel interventions that have developed over time since we last spoke. So we have PrEP in oral, in rings, in monthly, in bi-monthly, in 6-monthly formats that we could still sell, evidence that we didn't have, and that this is more acceptable, and that this can be given to cohorts of individuals in aggregate settings, and this will be beneficial to even the prisoners. So you sell it in a way, we just discussed with Dr. Kak, that there is some trade-offs for the staff and also for the prison population or the inmates themselves, and you speak to efficacy. It's unfortunate that the condoms are still not getting a grip, and also part of the hardcore harm reduction. I don't know how South Africa seems to be doing it with the needle and syringe programs in prisons, but I know we are going to struggle with those in most of the African countries. But if there was language to speak to the harm reduction innovations, we would really love to learn from others what they are saying and see how we can start up. There is pressure from the Global Fund to do so, but there has been an absolute pushback to any of those commodities.
Thanks, Humphrey. Just to flag, there is at the moment not a provision around harm reduction. But if people think there ought to be a provision, and it was suggested in the technical working group that there ought to be one at least about substance abuse and persons who use drugs, I think what would be useful would be to hear from those countries in which the use of drugs using syringes are quite high. And I know in some countries that would be your bulk way in which prisoners access drugs, in other countries not. So it would be useful to also see what sort of responses people have, and if there's a specific, how one include that in oversight. Lesotho wants to really tell us if they throw in condoms on prisoners or not. Yeah.
All right, thank you. I just wanted to comment on the issue of how we can talk about HIV prevention in the model law and other relevant documents without mentioning condoms, which will trigger some kind of negative attitude towards the whole document or the whole exercise. When we started rolling out condoms in my country, there was no law backing us to do that. But in 2016, we developed a Lesotho Correctional Service Act, which actually mentions or gives the Chief of Corrections the powers to put all preventive measures in correctional institutions. It doesn't mention condoms. So it just says preventive commodities. So we know when it says preventive commodities, it allows him to roll out condoms and lubricants. And right now we are rolling out PrEP in all correctional institutions. We are actually inviting inmates and training and educating them about the importance of PrEP whenever they feel that there's risk or there's danger to their life. And most importantly, we encourage those that are about to go home to present themselves to a health facility for PrEP so that they are tested, and if they are HIV negative, then they start taking PrEP and go home, hopefully well protected. Thank you.
Very useful. Thank you very much. We love listening. Question though, whether the preventive commodities is in terms of what the prison provides that they decide on, or is it specifically in relation to HIV? I'm just thinking that, for example, during COVID, preventive commodities would have included masks. So it might be easier to sneak in preventive commodities as a general provision. I'm just putting it out there. We can keep that in our back pocket if people start getting difficult about the direct wording, and see if that takes us any further. Was there a hand that I missed out on? Can we please move on? People, I know this has been a very, very long day, and I can go on forever, I honestly can, but I also know that it's a very technical exercise and it's quite hard to, and you're now applying your mind in great detail to these issues. We have persons with disabilities, survivors of sexual violence, persons with mental illness, LGBTQI persons, old and infirm prisoners. I doubt we're going to get through all of that before 4. I'm just putting it out there. Lucas?
I've been looking around on the internet for perhaps a different way to categorize this. And now the health professions must come in so that I think we use more health appropriate language when we're talking about monitoring particular groups. And it may be an alternative to focus rather on types of diseases, illnesses, and conditions, so that we, instead of saying we want to focus on a particular group of prisoners, rather say that oversight must pay attention to communicable diseases, to non-communicable diseases, to mental health and substance use disorders, reproductive, maternal, and child health issues, injuries and violence-related health conditions, environmental and occupational health risks, and then structural and systemic determinants. So I don't know if bringing that focus in as opposed to looking at specific groups may be a way around the...
I mean, there are other vulnerable issues linked to groups outside of the health issue, but... Yes. Okay, let's just look at, we've got, for the next 15 minutes, then you can go and we can take this up tomorrow. Let's debate this. Lucas is saying, instead of us focusing on specific groups, so let's not focus on people's status, let's focus on the issue where they might be vulnerable on. And he mentioned if we look at HIV, at health, so we can have a health section. And then under the health section, we can look at communicable diseases, non-communicable, reproductive rights, maternal health, substance abuse, what. That means we're actually adding quite some depth to our oversight. Now, the question here is, do you need that level of depth in a model law on oversight, or do you want that rather as questions that you would have when you conduct the oversight in like an annexure or something like that? are there specific are there specific issues that an oversight body then needs to look at that would change how oversight is done? And I would sort of feel that a lot of that might then come in Lucas under the mandatory reporting and under the training of oversight bodies, so that they are actually prepared to. So if you have any oversight body, whoever does oversight, if they are trained on all these health rights and health issues that you find within a prison setting, then when they go to a prison, they're able to assess it, and they know what their duties are in relation to reporting and all those sort of things, and they ask the right questions. Is that what we're looking at, or would we want to, yeah, Doreen, please help me.
I think that's probably a good idea, particularly maybe, yeah, under monitoring and reporting obligations. And then we can, list the things that, health professionals would be looking out for to make sure that's in place, and listing it the alternative wording that Lucas found just now. And then a similar process under human rights, right, to try and then maybe work in for other kinds of oversight professionals, right, around LGBTIQ plus rights. That might be one way of thinking of doing it, to ensure that this passes, but then also it can be used at domestic level for any kinds of legal recourse, right? So the wording is indirect enough, but also clear enough to be included in protections, even in existing legislation, without necessarily, I don't know, yeah, if that makes sense. I don't know, but I think, yeah, maybe doing it that way might be most.
Okay. Our legal colleague next to you, did you want to say something? Did you want to?
That's exactly what I wanted to say.
Okay.
Agreeing with what, sorry, the name?
Lucas.
Lucas, yeah, Lucas is saying, because that's what I've been trying to advocate. Let's have one generalized provision under your human rights, then one generalized provision under oversight mechanisms as a checklist that they will be looking at all the oversight institutions in relation to healthcare. And then you'll avoid, you see, we encountered, I think Boemo is here, we encountered the similar problem when we were doing the GBV model law. We nearly cried, Boemo, remember? It was the whole day and the next day debate on one issue. Once you use those words, what the Honorable Minister was saying, you are in real trouble, your law will not pass. So just find a generalized definition. We're leaving it mainly to member states to decide who are vulnerable, who are not vulnerable, and things like that. And if you look at the model law on GBV, it will help, because at least that passed. Yeah.
Yeah, I guess part of sometimes wanting to, I think some of these can go to the position paper, because part of the development of the model law is also to continuously educate and carry on resolutions that have been adopted. And one of them was that we are not convinced yet. You come back to us later and tell us on entry how many were negative, during who became positive, post who became, so we can package some of this data for those who are already collecting such data to be able to flag it during the presentations. And you see, the webinars serve to also impart information, because they cannot go through the model law, but just to highlight certain issues around what will propel change and new thinking in most of the countries. Unfortunately, all the time, countries like South Africa, even the island states where they are dealing with concentrated epidemics, hardly speak out when the majority are saying no to a particular issue. So I agree that we must be careful. Further, with the convention, on the GBV convention, some of what nearly made us stuck was the perception that we want to sneak in through the back door certain definitions for. So I think we need to, if it goes to that level of the African Union where you have the Agenda 2063 and all those things, then we still have a long way to go. But there's a way, I think what Lucas says, where we can be much more broad and hope that we don't close out countries who are quite happy to innovate through their policies to make that progress that's required. And maybe encourage research. We must encourage research in the process, not just reporting, so that as we move along, countries are mandated to know what is happening. And we can't always be hearing, we don't know. We need that data. We know that there are other ways we can innovate to present that data as part of the reporting for this instrument.
Did you note that down, Lucas? Research. Okay. He's a researcher, so I'm sure he did. There's two hands at the back first, then there's Mauritius, right? And then Kitty. Oh, okay. So two hands at the back first.
Thank you again. So I'm also thinking that we are talking about prisoners' health, and then we have the general population health and the debates that are ongoing in the mainstream health conversations. So if we are talking HIV and it is a public health concern in the general population, are we going to drop it when we get to prisoners? I'm thinking in terms of testing, we encourage everyone to test every 1 year or every 12 months of their HIV status. What are we doing with prisoners? Are we enforcing that, we empower them to know that they need to take that HIV test every 12 months? So are we going to have, discrepant conversations in the general population, in the main discourse, in the main public health, and then when it comes to that population, we are going to sort of tread on eggshells, as well as, the conversation now is on primary health care and integrating HIV in primary health care. And I would want to think that, we want prisoners' health to be at the same level as what anyone will get in or out of prison. And if these are things that we are pushing in the mainstream, then we should also be pushing within prison so that they're not left behind. Thank you.
I almost want to do a standing ovation for you because that was such a brilliant point. It's always the health people that bring you back to basics. It's like we're skirting around issues, but we're doing this already in the public health sector. So why are we now going to do things differently in the prison sector? Brilliant point. Yes.
So I have a few challenges with kind of the direction we're moving in. One is that I think this oversight section actually is maybe could be mapped out a bit better, because, for example, when we're looking at each category individually, there are certain issues arising. Like, so for example, when we were looking at foreign nationals, there's a section where they should have access to an interpreter. But then when we get to people, survivors of sexual assault, then there's also a line about how things must be provided in writing and orally in accessible formats of their right to report a sexual assault. Like, so prisoners should be informed to that level through a formal notice provided to them. So do we then say if there are foreign nationals that speak languages outside of the national languages that this documentation is provided in, how do we reconcile their right to access this information? So I think we're continuously running into these little challenges where there are going to be conflicts among the vulnerable groups, and we could maybe adopt the idea of looking at what is the oversight function, what are the things that you should look at when you get to these places, and perhaps have vulnerable groups moved up into the introduction section, where we can have maybe a mapping of some of the issues that they experience, like xenophobia, sexual assault, predation, and all these other issues. And then I think secondly, with the LGBTIQ plus section that we've not touched yet, I think it's great that the drafters put this in. I know that there will be challenges, but even looking at what's going on in the region at the moment, we're seeing more and more recognition for intersex healthcare status issues. So we have governments that are seen as conservative, such as Zimbabwe and Zambia, introducing more formal recognition processes for intersex people, yes. Half of SADC, a lot of places. So we don't want to lose the momentum for that by adjoining it to broader LGBT issues. Then secondly, in countries like South Africa, one of the big questions, especially with foreign nationals, is your access to documentation. So for transgender prisoners, we are going to end up in a situation in South Africa where you can publicly access or go through your transition while you are in incarceration. That's already kind of being affirmed through the jurisprudence we have, and I think we're going to see more of those cases. So our bigger issue would be, instead of recognizing trans people as a vulnerable group, maybe recognizing that there is the need to access updating of your documentation or processes around your legal identity. And then that covers both foreign nationals and transgender people, depending on how we would frame it. Because I think with foreign nationals, we were looking at the xenophobia aspect, the language aspect, and then broader issues of statelessness or instances where you're arrested and seen as an illegal immigrant because you don't have documentation, but there is a process or a manner in which you can. And then I think my last concern was just kind of the financing of some of these issues. The oversight mechanism can look and check for things and then be told that no, it's not possible, there are constraints in this regard, there are constraints in that regard. So I think that's a big concern to look at in another portion of the document around guidance as to what is the basic minimum standard so that we can affirm the dignity of prisoners and their wards.
Yes, even the minimum standards is not being adhered to, but there is an issue tomorrow where we will discuss the parliamentary oversight specifically, which is where your budgetary issues are coming in. At the moment, it deals mostly with the extent to which portfolio committees are ensuring that prisons have a proper budget, and then in addition to that, how it's ensuring that prison oversight bodies are properly budgeted for, but I think there's a lot that one can do there. I would think that we ought to sleep a bit on the issue of vulnerable groups and come back tomorrow, because you've also raised a lot of issues about where there are specific nuances that one do need to consider. I can guarantee you transgender people in prison is very much a huge concern for prison officials. What do we do with them? Where do we put them? And there's so many issues there that the oversight body ought to be aware of, and this might be a way in which one can highlight it for them that they might not find in any other document. I don't know. So let's just debate all of that when we, no, not debate, but sleep on it, and we'll come back tomorrow and think. I do think we need to go through the LGBT section still. Mauritius and then Kitty.
I just agree with Lucas for the health section. We need to make the oversight law user-friendly. So we start with a big heading, health, and then we divide into communicable and non-communicable, because it needs to be like a map. Like if I have, in my country, I have a problem, HIV, I just go reference, I go to not communicable, HIV, this, I don't need to go into, let's just concise it up.
Thank you. Kitty?
Yeah, I think it's quite hard to comment without seeing it in front of you of what it's going to look like if you do go back to going to health, and whether we are going to lose those specifics that actually are important and that are like those one or two critical issues for each population. The other thing that I was worrying about also was losing those commitments that we were talking about, like where in that people living with HIV, where you're talking about the minimum standards, that we still try to have some kind of section where we remind member states of their commitments in terms of various key documents as well, not just international ones, but things like that are more specific, like those ones.
It's exactly 4 o'clock. Can I close us off with, thank you everyone for being so prompt. I just want to flag that we are going to look at mandatory reporting. And we mentioned here that there are some areas we need evidence for. Is there a way in which we can collect that data so that we have the evidence in the future and so that our parliament start getting that evidence? So there are issues that there would be, that one would suggest that there ought to be certain health indicators that prisons need to collect data for, right? But then you mentioned that we would want the data of number of people HIV positive at screening, of, like all those sort of things, how many people develop HIV in prison, like if there is that data, wouldn't it be good to have it? So I'm just saying that, as Boemo mentioned, that the key part of the issue is research. And we don't have a section on research, and we ought to include that also within the parliamentary oversight part about the need to be guided by evidence. But we might want to think about whether there's easy evidential stuff. I'm not saying we create a whole new data thing, but those of you who are health professionals who work in a prison, you know what data you have, and you know whether it's possible for that data to then guide us on policy. So I'm just raising that for us to think about, because I do think more disaggregated data on HIV would help us get to condoms in prisons. We just need to figure out, we don't say we want condoms in prisons now, but we do want to start collecting data on how many people get HIV in prison. And then that would set us up for the future. So let's all go sleep on this, or perhaps don't sleep on it, go shopping downstairs, and then 9 o'clock sharp tomorrow morning we'll be back here. Thank you very much, everyone. You were great today. Thank you.